Yes. I filed a petition challenging the order of the collector directing me, the entire family to vacate the house. Okay. The senior citizens of 2007. He has no power to direct on Section 9 of the Act. So I have, with my two minor children, I am staying. May I pray taken up tomorrow?
My lord,
notice was issued. My father retired since 2020.
Which year?
It is of the year 24/5. This year, notice was
my lord.
When
2 weeks.
Challenging the rejection order of non-payment of gratuity.
Non-payment of gratuity.
Since 24. Two cases are there, sir.
Yes.
My lord, all the pleadings are completed. 2014.
2014
billets. The billets. My lord, it's a simple matter. Petitioner is waiting for his postdoctoral degree, but university is not granting him the degree. Only the urgent matter is a second order petition, sir.
I'm a pardon.
1 week, my lord. Next year.
I'm pardon to check the transfer matter again.
Teachers transfer.
You are again. Yes, you let's say. Another is the petitioner is not getting pay scale of psychiatry.
Which is transfer matter, which is pay scale matter.
So one is 25,976 2024.
Pay scale matter after 2 weeks.
I may be pardoned.
Don't waste time.
I may be pardoned, your lordship. Lordship, I have filed an I-8 for amendment of cost title. The notice has not been issued due to the mention of wrong address.
Okay.
The salary of the petitioner is your lordship.
Though this matter
Obliged.
This matter is specifically adjourned to 30th July of 25 as it relates to appointment of LTI teacher.
Next week.
My lord, this is the matter IA for vacation of stay and construction of a CNG station.
CNG station
Yes.
to be stayed.
It has been stayed. It was supposed to come on 18th June. It has not been listed.
My lord, examination appeared, result published, but the certificate not issued. The examination appeared. Pass result available in website, but certificate not issued.
My lord, except 5th and 6th of August. Except 5th and 6th.
24 matter, lord. That means 24. Yes, salary.
Week after next.
My lord, the change the father.
Change of name. Educational records. Take it tomorrow. We have one judgment now. We have already given asked Mr. Mohanty.
Well, this salary should date maybe
2 weeks.
Week after my lord says.
Next week of next.
Week after next.
Legal has certificate was issued in favor of the petitioner, which has been cancelled by the sub-collector without giving any opportunity of the hearing to the present petitioner. And by that order of the sub-collector.
When it happened? When all this happened?
January 2005. Next week, lordship, because by the virtue of the cancellation, he has changed the record. Tahsildar has changed the record of rights.
Yes. If you succeed, you will get all them restored.
Yes, lordship. Fix a date, any date, lordship.
Next.
My pension matter 2022.
22 pension matter. Next. Yes.
Interest.
Page 1, 1 to 4. Page 2, 5 to 16.
Item 2, my lord.
Item 2.
On the board, I counter this case.
Item 2 is 24 matter.
Yes, ma'am.
What do you want?
1 week after. Opposite party will file counter. No, will after board of secretaries.
The request of petitioner.
No, my lord, opposite party, board of secretaries.
But petitioner, if he comes now, please wait. Let us see.
Yes, I will come.
1 to 10 are not mentioned in any standard high courts. 1 to 10 are not mentioned. Yes.
Page 3, 17 to 30. Page 4, 31 to 46. Page 5.
Yes, nobody. Yes, go to it. Yes.
Item 1,
Non-payment of pensionary benefits, all the retired benefits. Chief Director last occasion.
Then he will put signature.
Yes.
In the meantime, I have received instruction that petitioner has already put his signature, and another thing that some in audit para there is outstanding of rupees 2,08,000. For that he has been asked to comply because some amount is outstanding there.
No, you have money, his money.
Yes, but
You get that money so that he will challenge that also afterwards.
yes. Okay. Secondly, my lord, the principal has been directed to submit online pension papers. That is my instruction.
Online pension papers.
Yes.
They have to go through the principal.
Yes, principal to submit.
Already done.
Which-
They have already submitted.
That has already been done.
Done.
Yes.
That is also done.
Yes.
Then why pension is not paid?
The pension, AG will approve, then thereafter the sanction.
How many years have happened now?
20.
And 21/6/2025, after the lordship passed orders, first time they say that recovery is there
In
for the
May.
first time.
Let them recover.
In
They
May,
can make challenge that.
Yes, yes, I
You
have.
have other money also.
Yes, yes.
in May 25, he has submitted the papers.
In May 25.
Yes.
But already we are coming to August tomorrow.
This matter was before lordship on 18th. On 28th July.
No, that's all right.
Huh.
Why you did not? Why they should come to court to get the pension? Having worked for years, why are you making them driving them to the court? You are not East India Company. You are government. So I'll impose the cost of rupees 50,000. They should be recovered from the concerned official who has delayed pension. How he should survive? No disciplinary inquiry. Nothing. If you want any recovery.
My lord, she is getting provisional pension.
Pension is getting.
Yet. Only to regularize
By
that.
the regular pay.
Man.
After a lordship direction, they paid.
This is advocacy. Otherwise, I would have imposed 50,000 rupees because Apex Court said, take out that Padmanabhan Nair versus so and so. Padmanabhan Nair. Nobody in the court.
The provisional pension was also not paid because the lordship intervention.
You are not coming with your arms na, to the war field. Where are your weapons? You have come to the war field as if you have come to marriage only.
They said that they will
That
comply.
may say 100 and odd things. If court understands the language of law,
Islands.
again to be
I'm sorry. I'm sorry. I'm sorry. Extremely.
Yes, sir. Brother, when are you sanctioning that thing?
Not sure.
When you were additional, who is that? Accountant General.
Yes.
He is not from England. He is one from India only. And he is also Indian. When will he pass the order?
Your lordship may give some time.
They have,
Already time was given.
they have to only send the to age.
What you want actually from him? Money. Paisa chahiye?
No.
Huh?
No, because of this audit para and
You audit para. You should have asked him.
he didn't put his signature in the pension paper. That is on the record.
No, it is, you only said he has already put the signature.
Yes.
26/6.
Therefore, when are you going to sanction this? Next time I will ask
Two months.
your
time.
accountant. Why 2 months?
In process, it will take time.
Is there any other problem?
One problem is that your lordship may see the audit para is there that your lordship is saying that your lordship.
You take action, you issue notice to him. Ask him, we want to deduct so much money. He will give some answer.
Yeah, the notice
You
has been
take a
issued.
decision on that. Finalize the pension papers.
On 26th June, notice has been issued to him.
26 June.
25. First
Yes.
time.
For the first time.
Yes.
What you said to that?
That I have not never that those on the account which they claim the amount recovery is to be made, that I have not done. I was not in charge.
Did you tell them? I am not.
For the first time, they have on 25th they have said that after your lordship passed order, they said that this recovery is there. 22, I have written.
You send reply today.
2000, I have to collect the documents because those were of the period 90 or something. Your Lordship, or they in the notice they have not. That is the 2000.
What is that?
2001.
What is not notice? Just read out. Give them. Just read out. I will not read your papers. You read out. Let all people sitting in the court hall know
Yes, sir.
how the government works.
There is your Lordship may say, TA bills for the year 96-97, then shortage of service postal
96, 97.
Yes.
How he will remember? He is not Shakuntala Devi. What happened in 96, 97? What happened when Alexander had come here? How he should remember? 96, 97. Now in 2025, you are asking him. In 96, 97, you had taken particular tablet and you pay the money now. How he will remember? Next date, everything should be cleared.
Notice has been given to him. Let him reply. Then thereafter.
Reply is sent now.
No. We have issued notice on 26th June. He has not yet replied.
Not yet replied. But he has to collect documents of 25 years. At least 18 years.
What I suggest, my lord, your Lordship may dispose of this writ application, directing the authority within 2 months, everything will be clear.
They have to only send those.
Do you agree with that? If you give undertaking, I will do that. Otherwise, I will impose cost. If you give undertaking that petitioners' pensions shall be sanctioned on regular basis within a period of 2 months, after deducting, if any, dues, so that he can file that.
Yes, your Lordship may call it next week.
No, next week.
The officer to give you undertaking.
Ask your officer where from he has to come. What? Ask him here. Password.
Principal, Principal Denkanal Maila.
I do not know.
Denkanal Maila.
Which place?
45 kilometers.
45 kilometers. We'll file it tomorrow. Day after we'll file.
Day after.
File this matter. Day after for further hearing. Since apparently one or the other bureaucratic issues are raised in delaying payment of regular pension, in the delaying sanctioning of regular pension. First, your officer should be here. The responsible officer of the AG office shall be personally present before the court for answering all the queries. I to take a decision tomorrow, day after tomorrow. Decision, first time. Call day after tomorrow.
Your Lordship knows the recovery also not barred by limitation. That no proceeding, nothing.
No, for government there is a different limitation period. It is not ordinary limitation.
96.
Let us see. They are saying that way, no? Let us see. You are not saying, see, 25 June they have sent. You have not replied it. No more than 2 hours.
They have not.
Over.
Yes, they have not. They have just.
They are not given to it. They have given notice. I share a copy of that notice with your friend.
Yes, I shot.
Yes, yes. Yes, item public. You can't harass the pensioner. What the apex court said in Devaki Nandana Mishra versus State of Bihar. Pension is not a bound. It is deferred salary because they have worked.
When the petitioner does not cooperate, then you.
That's right. Now he says he has sent the papers
he
also.
put his signature since 22.
That is not correct.
May 25 we have signed.
There is fault on your part also. Anyway,
from the record I'll show that that is not correct.
Let us see. Things should have moved from through the principal because they have certain rules that they have to follow.
Yes.
Yes. Yes, sir.
I am property, but I have some.
Yes. Call after 2 weeks. Reluctantly adjourned by 2 weeks at the request of opposite party. Okay.
Item 3,
Minor.
My lord, the matter is we are posting up under a rehabilitation scheme. The order was passed to serve a copy of Mr. S.S. Rao, who is the lawyer of the Board of Secondary Education.
What is your grievance?
But due to the non-availability of the S.S. Rao, I could not serve the copy of the petition.
You are serving now.
My lord. 1 week time may be allowed to serve the notice, to serve the copy on Mr. S.S. Rao, who is appointed for the Board of Secondary Education.
Petitioner is permitted to serve a copy of the petition along with all the documents on learned panel counsel Shri S.S.
Rao.
Sorry, sir.
Your lordship granted 2 weeks time to the counsel for the board just now during mentioned period.
Same matter.
Yes.
Serial number 2.
2.
All right. You serve copy.
Somebody was mentioning on behalf of Rao. Somebody was mentioned on behalf of Mr.
Serve copy on Mr. Rao. 2 weeks for serving copy of the petition along with all the documents from the parent of the claimant for the copy number so and so.
Matter item number 3, matter. Item number 3, matter.
Item number 3.
Item number 3, matter. Your lordship last time will answer to supply the copy of counter evidence matter. Till today, they are not supplied matter.
Who appears for the petitioner?
Is
You are for whom? Madam. Sister, for whom you are appearing?
My lord, the last time given direction to supply the copy of counter evidence. Till today, they are not supplied to me, my lord.
You filed counter affidavit on 28th July.
Second copy.
I'll solve the copy.
Yes. Learned PGA, in all fairness, submits that you would serve a copy of the counter on the respondent of the counsel appearing for the petitioner. Call of proceedings.
Item 4.
In item 4, my lord, I am challenging the order passed by the director under Annexure 6, rejecting the re-employment of a teacher on the ground that prior approval was not obtained by the director, not obtained from the director, and secondly on the ground that there is no policy decision of the government to give or extend re-employment. Well, for a moment,
When you were employed?
Your lordship may kindly turn to Annexure 2 at page 32. The school has 2 teachers.
When were you employed?
Well, I was re-employed. Umesh Chandra Das, one of the teachers of that school, he was re-employed on 1/3/2025 to 28/2/2027 for a period of 2 years. 1/3/2025 to 28/2/2027 for a period of 2 years in accordance with Rule 19 of the 1974 rules. Because the school has only 2 teachers. One teacher, that Umesh Chandra Das, he retired from service on 28/2/2025. Since no teacher was sent to that school, therefore, in exercise of the power under Rule 19, the managing committee gave re-employment to Umesh Chandra Das for a period of 2 years. For a moment, you will also kindly see Rule 19 of the 1974 rules in that education manual.
Please read.
19. Superannuation. If
you read, I can understand.
Yes. Every employee shall retire on completion of 60 years of age. Page 990.
Every employee shall retire?
Every employee shall retire on completion of 60 years of age. Then proviso is there. Provided that the director in respect of an institution other than a college and the government in respect of a college may, on an application by the managing committee or the governing body,
as the case may be.
Extend even.
Sanction re-employment in any case for a period not exceeding 2 years on any occasion.
On any occasions.
Your Lordship may kindly come to page 990.
Yes, you have read it.
Yes.
Is there anything new in that?
Now, Your Lordship may kindly see, this is second round of litigation. Earlier, I had approached this Honorable Court and this Honorable Court passed an innocuous order for consideration of the representation. Your Lordship may kindly turn to Annexure 6.
Annexure 6.
On which ground
what ground
it has been rejected?
Last say there is no state policy on that.
Yes.
First one. Number two, they said
no prior approval. No prior approval.
No prior approval.
No prior approval. And another ground is they have referred to one government circular dated 12/9/2024 at page 39. That is meant for government servant, not for employees of aided educational institutions. I have also annexed that circular under Annexure 7.
This applies only to the government servant.
It only applies to the government servant, not to the employees of aided institutions.
When you retired, actually?
Well, I retired on 28/2/2025.
28/2/2025.
On attaining the age of superannuation at the age of 60 years.
And you were engaged
from 1/3/2025 to 28/2/2027.
But rule says how many years?
2 years.
2 years.
2 years.
And now what happened?
Now, well, that has been rejected by the director. Rejected on the ground that prior approval was not obtained. Second ground is there is no policy, no rules for the employment.
Rule itself says, no?
Yeah, rule itself says.
What do you say?
First of all, he has no locus standi to file this writ application. He's not the person aggrieved.
No, managing committee has.
No.
Managing committee is espousing the call of the teacher. The managing committee is required to pass a resolution. Unless the managing committee passes a resolution, a teacher cannot be re-employed. Now, therefore, the managing committee is before your lordships because the school is going to be affected.
But you can read the rule again.
Yes.
How rule is individual specific or management committee?
Yes. Your lordship may kindly see. Rule 19.
Every employee shall retire.
Yes, then provided that the director in respect of an institution other than a college and the government in respect of a college, this is not applicable to me.
As the case
may on an application by the managing committee or the governing body. As the case may be.
Employment.
Yes.
The sanctioning is to the recruiting committee.
Yes.
It cannot be anybody else.
The present petitioner is not authorized to, he's not the part of the management.
But managing committee has done.
He's saying.
Yes.
Yes, SMC is part of the, he's not part of the management. And secondly, the 1974 rule does not apply in the present case.
Does not apply?
Yes.
We
have already.
Kindly be seated. I will pass any adverse order without having heard from you. Kindly be seated so that you may not embarrass him.
Yes.
I also get embarrassed.
Yes.
You may be right in saying.
Yes.
But we should also hear the government.
We have already filed and counter affidavit on 28th July, giving all the details.
What are they?
Your Lordship, whether it is in
your first contention needs.
Yes.
The first, kindly be seated. I should hear this. Otherwise, I'll adjourn this matter. Resist your temptation.
I am not saying
Resist your temptation.
Yes. Your Lordship, can speak?
Learned counsel for the petitioner invokes Rule 19 of 1974 rules to contend that even after superannuation, the director has got discretion to appoint a superannuated employee for a period not beyond 2 years. First, he submits that. The management having applied for sanction to make such appointment, the government is not just the answering respondent is not justified in rejecting the same on the ground that there is no prior approval of the director and that there is no policy evolved by the state in respect of this. First of all. Your contentions are what? You have taken two contentions. You cannot superadd the contentions now.
Yes, Your Lordship, we have taken the first contention in paragraph 17 of my counter. Saying that as indicated in our rule, for a re-employment under Rule 19 of Odisha Education Rule 1974, subject to sanction of the same by the Director of Elementary Education Odisha Bhubaneswar, while the Odisha Education Payment of Grant in Aid to the Higher Schools and Upper Primary Schools Order 94 and 2004 was not introduced. After introduction of Odisha Education Payment of Grant in Aid to the Higher Schools and Upper Primary Schools Order 2004, the Odisha Education Payment of Grant in Aid to the Higher School and Upper Primary Schools Order 1994 and Odisha Education Rule 1974 is ipso facto superseded. My Lord's friend is citing the 1994 or 1974 law. Then secondly,
one second. Let us process that. The rule is superseded by the Grant in Aid Code.
Yes. Previously, it was a private.
These rules are promulgated under which statute?
Odisha Education Act.
Education. And code is promulgated under which province?
No, it is not triggered on that.
Odisha Education Code, which you say that you are invoking doctrine of implied repeal.
Yes.
But it's a very slippery doctrine. By issuing code, you should have said all rules are repealed. Then you could have made the code, as Napoleon did in France.
Now, after these schools came into the granted action.
Answer my question. Because Apex Court said in Fernandez versus State of Mysore versus Fernandez. Can anybody take out that decision? Take out that decision. Said the code is not a piece of law. It is only a body of executive instruction. It's a 1967 Supreme Court, if I am right, 67 or 69, 67. No researchers from youngsters, young bar, nothing. Nauseating. Nauseating. I feel like committing. Nobody.
67 Supreme Court.
That is 67 Supreme Court.
67 Supreme Court says.
Fernandez versus State of.
Yes, yes.
Correct.
Yes.
Supreme Court say ordinarily, it was a case of PWD code. Ordinarily, the code does not have force of law. If that is so, how a rule is a piece of law? How a piece of law can be repealed by the executive? It cannot be. Will you come with more preparation?
You'll also call our, we have already filed the counter.
That makes no sense.
We have detailed in the
You are saying the rules are impliedly repealed. It is possible. Shirwai discusses doctrine of implied repeal. Suppose there are two statutes. One is old statute, another is new statute. The new statute and old statute do not get together. They are like mongoose and cobra. Then Supreme Court said the later statute repeals the earlier statute. But the rule, which is a piece of delegated legislation, which you will study in administrative law, S.P. Sate, Jain and Jain, Pasu, etc. Wade, Pasit. A rule is a delegated legislation or a subordinate legislation. Okay. A subordinate legislation cannot be silenced by executive instruction. This is what we have been taught during our law school days. Great Professor Dr. Vishweshwaraya used to teach this way. Therefore, look into that, come with full preparation. Got the point? Otherwise, piecemeal, I have to take the class to you. That's not my object. The president has appointed me to do justice, not for giving lecture. But unfortunately, the whole bar appears to be, I will not complete the sentence. Whole bar, whole.
7(4) of the Orissa Education Act. My lord, his argument is that since the school received block grant from the state government, not full grant in aid, therefore it is not an aided educational institution.
That may not be correct.
You also have already seen
grant also. Definition is.
Yes, section 3B of the Orissa Education Act. But therefore, they say that 74 rules is not applicable. If your lordships will read the nomenclature of the 74 rules, it is meant for aided educational institutions.
None, not other than aided.
And there is a judgment of this Honorable Court of Coordinate Bench in Vajanti Nayak's case that even block grant schools and colleges, 74 rules is applicable.
Do you have that judgment?
Say, just now I don't have, I will survey, I will give you a copy.
Therefore, I will give you time to make full preparation. I request bar members to become more efficient.
Come with judgments.
Because foreign lawyers are coming. Where will you go? Do you have land to go for cultivation? How will you compete with them? With this substandard preparation? How are you going to earn your livelihood? Tomorrow, if English lawyers, French lawyers come here, what will you do? What will you do? Please understand this. I will be here. I can be very pleasant to you for 1 year and go happily after saluting Jagannath, Lord Jagannath. But that is not my purpose. I have come here. Make best use of me. Little things I may be knowing. You are more knowledgeable. But put it into focus. What are you going to do when foreign lawyers come here? Lord Jagannath cannot accommodate you. You have to do something. You have to read, make notes, upgrade yourself. Then you will be able to live. Otherwise, in some countries, when European people went there as competitors, the countrymen committed suicide, not suicide. Read history. When Europeans went to other countries, the competition level was so high, the local people committed suicide. That should not happen. Because world now, Vasudeva Kutumbakam, whole world is becoming one now. Make use of that. Don't mistake me for saying these curt words. Kindly do not mistake the judge. Judge, as a student of history, is predicting. That's all. He may be wrong and he'll be very happy to be wrong also. Small questions are not answered.
Let him serve a copy of the counter.
Give copy. Give copy.
Interim order to continue.
Interim order to continue till next date of hearing. Since a prima facie case is made as to invocation of proviso to Rule 19 of 1974 rules. Call in first week of September 2025. There is one judgment, ILR 1997, Karnataka. I don't remember it was argued by Mr. Ashok B. Hinchigiri and Advocate General Vijay Shankar. Okay? So just find out, it is in your favor. It repels your contention. It is about Karnataka Education Code and Karnataka Granting Aid Code. Where's Apex Code? It's our code said, Karnataka Code. This is also my code only. The Karnataka Code said, the code, the granting aid has no statutory force. Just look into. Okay?
Item 5.
And do not argue half-heartedly the constitutional doctrines, like doctrine of implied repeal. Make research on that law. Lot many judgments are there. Make research and come back.
Item 5.
Well, so this is a matter pertaining to not publication of result. I just received the counter
Receive the counter now.
Yes.
One time to go through.
Next Monday, my lord. So, next Monday, my lord.
Monday, many matters we have posted. We'll have this next.
If lordship, as your lordship thoughts.
Next.
Short date, because it means matter related result.
My lord, if my lord permits, I'll file the counter here.
Yeah, we'll file the counter affidavit in the register so that they know format is complying with or not.
Item 6.
You should not take the judge for telling all these things. Okay? For telling all these things. It is more a suggestion to the youngsters.
Item 6.
My lord, applicant retired 1 day prior to his date of increment, my lord. As per Finance Department Resolution Memorandum, Annexure 4, my lord, that is, he is eligible to get notional increment in the pension only. But it is already judgment passed, my lord, that is Annexure 3. That is Annexure 3, page number 14, my lord.
There is no communication between the bar and the bench in view of online proceedings. Come on, call this matter after 2 weeks. Yes.
Item 7.
Merit. Now, the petitioner was engaged as a outsourcing agent for operation of one route under Odisha State Road Transport Corporation. For the purpose, he signed an agreement and 1,50,000 rupees was deposited as a security deposit. After the term is over, since last 6 years, that amount is not being refunded to him.
For the first time, it has come now.
My lord.
It has come for the first time.
Yes, my lord. First.
They issue notice. Why are you retaining their money?
Not only the corporation. My lord, in that case, my lord, I have given one representation, my lord, and extra 5 is pending.
If they consider that, you will be happy.
Yes, my lord.
Perfect. The short grievance of the petitioner is aired in the representation at Annexure
5, my lord.
5. Dated
32.
Dated. Date.
Date, my lord. 28 January 25.
28 February
January
2025, wherein he has sought for refund of a sum of rupees 1 lakh after the accomplishment of
1,50,000.
1,50,000 after the accomplishment of the contract in question. First off, learned counsel for the petitioner submits that it is a refundable deposit and therefore it constitutes his property under Article 300 capital A of the Constitution, and therefore it cannot be withheld or its repayment be delayed. First off. Next paragraph. Who is your respondent?
My lord, OP number 1, my lord.
Who?
Chairman of Magistrate of SDC.
Notice has to be.
No, my lord.
Panel of lawyers notice.
First, issue notice to OP number
1, my lord.
Then only one OP.
Only one, that is the authority.
Okay. Issue emergent notice.
My lord, I am permitted to serve copy with Mr. Amitav Tripathi.
First, in addition to taking usual steps, it is open to the petitioner to serve copy of the petition along with all the documents on the panel counsel.
Mr. Amitav Tripathi, retainer of SDC.
Anyway, we call it panel counsel.
That may be
2 weeks. 2 weeks.
That may be fixed.
It will come. Yes.
Item 8.
My lord. This petition has been filed under Article 226 of the Constitution of India, seeking appropriate direction to the Development Authority, CDA, to conduct municipal corporation and other public authority action against grossly illegal and let me complete. Unauthorized issue notice. Unauthorized construction carried out by Oshia Tower Private Limited.
He is saying issue notice.
Notice already has
Notice
issued.
already issued, my lord, in this case. We have appeared in this case, my lord, which time may be given to file the counter, my lord. For
When
that
notice was issued?
Notice was issued on
I have appeared on 17th, my lord, of this month, my lord.
How many months you need to find the...
No, my lord, only 2 weeks, my lord. Only 2 weeks. Only 2 weeks. Another 2 weeks, my lord. Because the copy has been sent to the
learned counsel appearing for the panel counsel.
My lord, I am a retainer, my lord, on behalf of the
Retainer counsel appearing on behalf of respondent number, OP number.
OP number city.
OP1, my lord.
OP1 is granted a period of 2 weeks for failure.
Correct. One is state. OP2.
OP2.
My lord, once.
You don't bring your file also.
My lord, I have received only one copy, my lord, and that copy I have sent to the CDA, my lord, for instruction. For that reason, I don't have any.
To call after 2 weeks for filing statement, the counter, to failing. Failing which, right to OP2 stands for fitted. You also can file. Call after 2 weeks.
Item 9.
Yes. The present petitioner, and there are other 3 matters in the court. They were before this honorable court for stoppage of their periodical increments in the earlier occasion before this honorable court. That has been stopped in 2008, my lord, on the premises, in the wrong premises, my lord, because they say there is a vigilance case pending against her. But the vigilance directorate has given a clear notice that is there on record. There is no case pending against us. And that is by taking note of that submission, my lord, kindly turn to page 12 of the brief. I have quoted my lord's order in the last, on 8/4/25. This case.
8/4/25 order.
Yes, my lord. This is not in this case. Previously, we were before this honorable court.
It's covered by the judgment.
The same persons were before this honorable court for the self-same relief. The case was disposed of because there was no vigilance case. Direction was issued to them to release the periodical increment of the petitioners. And that order.
Where is that order?
My lord, page 12, I have quoted that order.
What is?
My lord.
But ordinarily orders themselves should be produced.
Yes, my lord, because there is
wrongly typed and something happened. Because you are basing your relief on that order. That
yes,
copy itself should be produced.
Sometime
where is that?
My lord,
there is no other legal impediment.
Yes, only they say the honorable court has directed, if I will permit me, para 6 and 7 will be important. Mr. Das Leonard, it's a standing counsel.
Benefit the extent of so and so. You should not read the name of the lawyer.
No. That is the statement of the learned advocate.
You are not supposed to take the name of the lawyer at the bar because it will be advertised. That should not happen. You should say so and so.
Oh, sorry. My lord, that is the statement on the statement of the learned standing counsel. The order was passed. Last standing counsel on instruction also fairly contended no criminal proceeding is pending against the petitioners.
Why, brother KGA?
Yes. Now it is rejected.
Why you have rejected? There is an order.
They say that there is a legal impediment.
We are asking.
My lord.
You say there is no legal impediment at all. You say vigilance case. And the material records show there is no such vigilance case. And there is already an order. In this order, that relates to which increment? Why again you are here? Already you have
my lord have disposed of this authorities to pay the amount. Now they have that has been rejected in Annex 9.
Again rejected.
It's same only on the, taking the clue from that order that if there was no legal impediment, they say that there is a legal impediment. What is the legal impediment? Well, now they are saying because in some other case, my lord, vigilance case is not this.
But such order should not be passed. Actually, we should not say if there is. If it's a very dangerous word. Very dangerous word. Here there is one poem by a famous author. If there is a poem, you forgot the name of that author. The
File counter.
No,
you want to file counter?
2 occasions they have taken time.
Twice you have taken time. We'll
My lord have
1 week
granted
time. 1 week time to file the counter. And I will impose very heavy costs in this matter. Because you have taken undue advantage of the last expression of the order, earlier order of the coordinate brother judge. If there is no impediment. That was Rudyard Kipling, the famous poem of If. That somebody youngsters may look into. It's very beautiful poem. Yes, we will give you 1 week. And I may impose heavy costs. Finally, a period of
you will grant us 2 weeks.
2 weeks to file objections if any. Failing which, right to file one stands forfeited.
My lord, item number 16, 20 and 74. Same. 16, 20 and 74.
Yeah.
Or
For
same.
these matters together.
Same.
Item 11, item 10.
May I please? My lord, petitioners are one of the villagers, my lord. There is a government, my lord, scheme for construction of a multi-purpose community center in the village in each block. Accordingly, money was allocated by the government. And my lord, under Annexure 1, land was also one particular land was also demarcated, identified by the authority under Annexure 1, running page 10. Is plot number 764, serial number 2. Thereafter, my lord, all of a sudden, my lord, another letter was issued after 1 year saying that this plot is not, your lordship, running page 10, the plot serial number 12, our Sadakpur village under Mauja, Khata number 331, that is 764. That is, my lord, in invitation to the cited, I am to bring you to notice that the following lands scheduled land has been identified for construction of multi-purpose community center.
Minorities.
That is. Thereafter, in the Korai village block. Thereafter, under annexure to the next page, again, my lord, after 1 year.
But what is the character of PIL?
No, not a PIL, my lord.
You are a villager.
A villager, my lord, villagers, we read objection that it is a Gochar land, and that land which was identified, it is a Basti Jogya land, and that apart, my lord,
Your right.
My lord,
Community right it will have. What is your individual right?
Individual right, my lord, in front of my house, my lord, the rent is also, rent is rent during rainy season, the rent flow is such that our houses are also causing the blocked by the water. That is why under Annexure 17, apart from me, other villagers also raised objection regarding another plot, another land, which is also in fact is a Gochara land that cannot be used for construction. And running page 17, we stated that, and pursuant to our representation, again, my lord, running page 7, running page 19, Annexure 7, BDO had also instructed that we had, with reference to the cited, I have to say that villagers of Sadakpur have filed a grievance petition alleging to stop construction work on the above land bearing plot number 317, which is selected for multi-purpose building, as the land is used for cattle grazing and also the water flow over the land during the rainy season.
Heard learned counsel by the petitioner. The prayer cannot be treated in regular jurisdiction. First off, apparently, petitioner is espousing a social action cause, and therefore, matter has to go before the PIL. First, registry to post the matter before the PIL court. If a second set is filed in 2 weeks, read PL Vadhera versus Union of India. Next.
They only sorted because they will start construction. That
you can't stop that.
Item 11.
Next week, you'll estimate that. Let me put it
within 1
mile.
If the second set is filed within 1 week.
May I please, Your Lordship?
Yes.
My lord, the present petitioner challenges the order of transfer on the ground that when there was an interim order was in operation by this honorable court regarding
Transfer of Deputy Commissioner.
transfer of a reader, my lord. Reader. Reader of a college, my lord. So during the subsistence of an interim order granted by this honorable court in another case, my lord, as regards continuance of the present petitioner.
Is it a transferable job?
Well, it's a transferable, jobs are transferable.
You admit that it is transferable from one institution to another institution. Transferability is accepted. How long you have been in this institution?
Well, initially that institution was an unrated private educational institution.
How many years you have been in this?
Since 94 months is from the date of my approval, my lord.
1994.
My lord.
Now transferred to which institution?
My lord, to another institution which is 50 kilometers out from the present institution, my lord.
whether your salary, perks and other things are affected.
Not affected. My grievance is that there is only 1 year left for my retirement, my lord. So once I am transferred within that period, my lord, the processing of my pension will be delayed, my lord.
We'll assure, we'll ask them to immediately start processing the pension.
My lord, my grievance, further grievance is that, my lord, earlier I approached this honorable court, that writ petition is pending, therein they had issued a relief order without giving me a posting order, my lord.
Now we'll ask them to give the posting.
Now they have given me the posting order. Then when the interim order granted in the earlier case was in force, my lords. In violation of that interim order, they have transferred me. And
now, is there any law which says within 1 year of retirement?
My lord, there is a policy of the state itself, my lord. They say that your lords may kindly come to case 52 of the present case, my lord.
52.
My lords, Annex 9. That is guidelines for transfer of non-government aided college common cadre teachers, my lords. Your lords may kindly come.
Sentence complete.
My lords.
So that I can assess. You are arguing, you are not narrating.
My lords. Guidelines, your lords, kindly see the subject, my lord.
Transfer guidelines.
Guidelines.
These are issued under which section?
My lords, this is a common cadre rules, my lords. This is 79 rule, my lord, which is a statutory rule, my lord.
Statutory rule.
My lords.
Because it is referred to rule particular 1979.
7 rules, my lords. So,
what it says?
My lord, invoking power under that rule, they have framed this guideline, my lord. This guideline says, my lord,
which protects you.
My lord, see.
Para 12, Roman para 12.
My lords, para 12, my lord. Superannuation, my lord. Teachers with 1 year or less for superannuation will generally not be transferred unless required on administrative grounds or exigencies, my lords. So here is, and as of today, my lord.
When are you going to retire?
31st July 2026, my lords. Just one.
That order is issued on which date?
That has been issued on, my lord, 26th June 2025. Then I was having only 1 year and 28 days, my lords.
The limitation, 3 years for filing a suit. If you file the suit next day, it will be dismissed. So it is said, 1 year. See the language of the rule.
So 1 year or less.
Ordinarily.
Ordinary. So my responsible submission, my lord. So I was only having 1 year.
1 month. Therefore, you cannot invoke the rule.
So, as my lord, so far as the very purpose of the rule is that one should not be transferred within 1 year. So,
what is?
I am in the second case for the private party who has transferred in that college. In view of the interim order, I could not able to join in that college, my lord. And my submission is he has been transferred within the district of Khordha. In the second one I have gone through. Yes, sir,
50 years.
50 years.
It's the intra-district transfer.
I have been transferred from Mayurbhanj to Khordha. I could not able to join.
Let's kindly see the prayer of the writ petition. This is for a direction to allow him to continue in a particular college. Whereas the impugned order, it is a chain of transfers of 100%.
General transfer, yes. Please be seated.
One more submission, my lord. Well, there are other lecturers in the college, those who are having longer period of service.
That's how
the opposite partners could have been transferred in that place.
Suppose can a thief, suppose a house is burgled by 5 thieves, burglars. Police have arrested 1 burglar, and that accused says, no, you have not arrested other burglars.
That cannot.
That way,
so.
Kindly be seated. He is a lecturer, reader
in physics, matters.
A reader in physics, working in an institution since 1994, who is to lay down the office on attaining the age of superannuation on 31/7/2026. Kindly be seated. Basant Bosya. He is grieving before the writ court against the transfer order dated
26/6/2025.
26/6/2025. First, next paragraph. Learned counsel for the petitioner submits that. All through he has been permitted to work in one institution since 1994. And now all of a sudden displacing him would cause enormous hardships. Semicolon. He has been satisfactorily working and there is no complaint whatsoever against him. Semicolon. The transfer is effected in a violation of the transfer guidelines and therefore the same should be invalidated. First, lastly, he submits that even those who have been serving in the institutions for longer period are spared, but he is singled out for unfavorable treatment. And therefore, the action is violative of Article 40. First, next paragraph. Learned AGA appearing for the official respondent. Learned private counsel appearing for the private respondent.
In second one, I am
In the second one. In the second matter.
There are two cases. There are two cases.
Both the petitions are by you only.
yes.
By you only. Make their submission in justification of the impugned orders and the regions on which they have been structured. First. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court declines in the matter for the following reasons. A. Admittedly, the post which the petitioner is holding is transferable. Second, he has been so transferred, wide order dated 26/6/2025, and it is an intra-district transfer. Intra-district transfer, to a place which is just about 50 kilometers away from the place wherein petitioner is presently working. First, an employee whose conditions of service do not protect against a transfer should scrupulously obey the transfer orders. Is the norm of public service. Wide. Varadha Rao versus State of Karnataka, AR 86, Supreme Court Soils. Next one. The second contention of the petitioner that he is in the verge of retirement and therefore he could not have been transferred is a bit difficult to countenance. Inasmuch as Roman 12 XII of paragraph Roman 12 of the transfer guidelines, which are stated to be having statutory force, provides for transfer except in cases where superannuation is going to happen within a period of 1 year. First off, the same reads as under. This is paragraph 52,
54 minutes.
54. Just open that. Next paragraph. The text and language of the said paragraph makes it abundantly clear that the rule is not mandatory, the paragraph is not mandatory, the guideline is not mandatory, in as much as it employs the word in words, the expression in words, generally not be transferred, and therefore cannot be pressed into service as a thumb rule. First one. Next point. The last contention of the petitioner, that those who have been working for longer period have been spared, is not a legal ground for invalidating the orders of the king. First, decision to transfer ordinarily is taken in abundant discretion, of course, which has to be exercised according to rules of reason and justice. First, a writ court has no reason to assume that this transfer is made sans reason and logic, especially when the petitioner had been in the very same institution since 1994. First, one cannot eternally cling on to a post or position or a place, is the rule of life. First, motion is inevitable in public service. First, in the above circumstances, these petitions being devoid of merits are liable to be dismissed, and accordingly they are, costs having been made easy. First, petitioner is granted a period of 1 week to join the duty at the transferred place, yielding place to the private respondent in the companion petition to occupy the position which is going to be vacant eventually. First.
The second petition becomes infructuous in view of the order of posting.
No, this common order in common petitions. Yes, next.
Item 12.
My lords, here the opposite parties are housing board. He has incorrectly made State of Odisha as party represented through Commissioner State Housing Board. Commissioner of a board cannot represent state. Now he has to correct this.
Learned AGA points out that defects in the description of the parties in the first item. First of it, a period of 2 weeks is granted to address the defect by the counsel, by the petitioner, Call up for 2 weeks.
Item 13.
Item 13, my lords, on behalf of Mr. Jena, my lords, may kindly call it after lunch. Pass over. My lords, Hon'Ble.
Item 14.
My lord, item 15, the petitioner is elementary cadre level A teacher.
Elementary
Cadre level A teacher.
Level 80.
Assistant teacher. In order to get a promotion to the level AB, that is a senior teacher, OTT test, Odisha teacher eligibility test is required. But the law says, as per the Annexure 6, Odisha Elementary Education Method Recruitment and Condition Service and Officers Amendment Rule 2019, 15 subclause 1D1 says that who has appointed prior to 11/2/2011, OTT test is not required.
Not required. You are appointed before that.
Yes, my appointment order is annexure.
No, you have said that.
Yes, I have
doubt you.
Yes. Appointment order 1/1/2005. And prior to that date, my responsible submission
Where have they?
not required to pass out to the OTT test for promotion.
Understood. Where have they denied your?
No, my lord, it is a fresh admission.
No. Where have they denied? Which order you are challenging?
My lord, Annexure 1. Annexure 1, government issued letter, government school and mass education issued letter to the director elementary education. My lord,
They say even before 11 to 21 also should be.
yes.
That's an issue emergent notice. Learned DG is requested to accept notice for the respondent. First of matter lies in a narrow compass. Calling first week of September 2020.
My lord, it is sorted to similar matter pending. This honorable court listed 69 serial.
When, which is that? Give. All this matter
69 serial.
along with 69.
Yes, today list.
Today's list. Same order in 69.
Here in 69 that item, batch of matters are there where government is to file counter because in a similar case has been disposed of by honorable single bench. That is Dibakar Bari case.
Covered by judgment.
Covered by judgment. That government has to clarify whether this will be covered or
Will
not.
be separate.
This will be along with that also that can be.
No, there I have to look into. I will not. I may not grant time at all unnecessarily because the government has to be active. It cannot sleep. Yes. On it.
My matter may be hard analogous with the 69.
Let's see. I'll call up the 2 weeks. Okay.
My lord, issue notice.
Yes.
Short date may be given. My lord,
2 weeks.
Or 2 my lord.
Yes.
My lord, my similar matter, serial number 15.
15, 1 5.
Part.
1 5 also.
And 19.
15 and 19.
15 and 19.
Same order. All together.
Item 17.
Yes, sir.
As a peer petitioner has been appointed under the compensation ground in the year 2018.
He retired in 2018.
No man, appointed against the junior clerk post under compensation ground.
Passionate ground.
My lord, under the rehabilitation scheme in the year 2018 on contractual basis.
2018 on contractual basis.
Thereafter, my lord, she objected the appointment under contractual scheme and filed a original application before the honorable tribunal. Thereafter, after abolition of the tribunal, again the case transferred from this honorable court and this honorable court passed an order for consideration taking into the considering order passed by this honorable court in terms of the another order, another
similar
matter. Accordingly, his service has been regularized in the year 2023 at age number
23. It is done.
My lord,
What is your complaint now?
service has been regularized, but
Date should be antedated.
antedated and no financial benefit have been accorded. Only notional basis his service has been regularized with effect from 2017, my lord.
Mr. AGA, we had similar matters where notionally, Mr. Vanti, notional benefits. Similar matters we had. You take notice, we'll bunch together all those matters. Then one day we can pass order. Issue emergent notice. Learned AGA is requested to accept notice for its respond. All respondents. First, call this matter in the second week of September 2025.
Item 18.
Yes.
The petitioner is a peon who got retired from service.
You can turn the mic.
Son is a retired peon in a college, in a aided educational institution of Odisha.
He's a teacher.
He's a teacher. No, peon. Peon of an educational institution. Credit education. So he got retired as per Annex 6. His date of superannuation was 31/7/2020. While he was in service, his sister made a complaint with regard to his date of birth entered in the service book. Accordingly, director made a unilateral inquiry and came to a finding that my date of birth entered in my service book is wrong. Instead of say 54, it is mentioned as 60. So I approached this Honorable Court against the finding of the Deputy Director Higher Education. This order was passed under Annex 1, directing the college authorities to make an inquiry. The inquiry was conducted by the college authority. College principal came to a conclusion that my date of birth is correct in 60, not 54.
You are born in 60.
I was born in 60. That is the finding of the
6 years will be variation.
Yes, that was there, Miller. Yes, 6 years difference.
Too much.
Oh, Miller, that is the
1 year, 2 years.
Because that is not the question, Miller. Question is the entry was made on the basis of educational institution report. And that educational institution was burnt subsequently. That is the dispute for which my sister made a complaint, none else. My own sister made a complaint that my date of birth should have been this. Accordingly,
be anybody.
Yes,
truth, satyameva jayate.
Yes.
Whoever may tell the truth.
In fact, there was an inquiry conducted by the principal. He arrived at a conclusion that my date of birth is 60, not 54. And it was given to the government for correction of their my service book. And it was not done, for which I approached this Honorable Court. Once again, Annex 1 is the first petition. Subsequently, I approached Annex 3. Annex 3, this Honorable Court directed to take a final decision, gave a direction to the government. Government considered. It was not considered. Then Annex 4 is the order where all of a sudden this Honorable Court passed an order directing the crime branch to make an inquiry. The crime branch made an inquiry behind my back and came to a conclusion without any original document that my date of birth is not 60. It's not said what is my date of birth, but not 60. Whatever entered in my service book is not correct.
We'll direct our court physician to examine your client now.
Right now. Yes, Miller.
The bone, there are...
Yes, it can be ascertained, Miller, what is the date of birth. What would be the exact? Yes, fact remains, Miller, I continued as if my date of birth is 60, pursuant to the order of this Honorable Court. I got retired. And now I am only getting...
the inquiry.
Pardon?
You were not heard in the inquiry.
No, Miller, no inquiry has been conducted as yet. First inquiry was conducted behind my back on the basis of a complaint made by my sister. And the director came to a conclusion my date of birth ought to have been 1954, not 60. And then this Honorable Court stated...
How director formed that opinion?
That he made an inquiry, internal inquiry in the institution where I am studying.
How many brothers you have got?
I have 2 brothers.
What is the date of birth of your brothers?
But I have not... I'll...
Petitioner is directed to furnish dates of birth of his brothers, sisters, and also the approximate age of his parents.
The educational institution records...
Are you married?
Sir.
Is he married?
Yes, Lord, he is married.
Petitioner to furnish the date of birth of his wife as well. We'll decide here.
Wife and children also.
When will you call this? We produce these things. I will decide that matter.
Week, 1 week, within a month.
Call this matter.
Week after.
Week after. Let the request on. This time is taken by the counsel appearing for the petitioner himself. Very simple thing.
In fact, he has not studied up to matric. He is under matriculate.
But his education records?
Yes, that was submitted. That, according to the crime branch, it is burnt.
No, let us see. How it is burnt?
Burnt because of fire. Incident, affair was lost and affair also...
When it was lost?
In 1972 or 72.
Only what all is burnt in the fire? Only your records?
No, the entire institution was burnt and affair was registered, affair found to be correct. It was closed. Fact is true.
Modi's Medical Legal Jurisprudence, yes, very standard book. He gives how age of the candidate should be determined. Bring that page also, Gerard's page. Okay?
Yes. But in fact, he has completed his 60 years, as if his date of birth is 1960.
Item
He has
21.
completed it.
Yes, he has already
Then
retired.
increments now.
I am not, they are now paying me pension.
For what period?
But till 60? Till I retired from service?
Brother, you worked till 60.
Yes.
If he has worked, how can you deny?
That is the only issue.
My lords, my friend may direct to be serve a copy, my lords. I don't.
Copy. I'll serve a copy unless I serve a copy. How can it be listed?
One more copy.
I'll serve it. Just
Along with cup of coffee.
yes, no problem. Absolutely. I just
So, if he has worked, you cannot deny.
My lord.
That's what Apex Court said no, under Article
I have not
23.
gone through the file, my lords. It was not.
I have already served section I am serving.
In the meanwhile, issue notice. Learned EGA on request accepts notice for the respondent.
But that previous order will be remain there. Or I'll serve the copy. Because I will already served.
Let us see.
Item 21.
That period may be excluded while computing the qualifying period for the computation of pension, terminal benefit. But the salary, etc. cannot
Salary
be.
I have already got. I have already got. Yes.
Let us see.
I think pardon.
Just look into the decision of Supreme Court. The state of Rajasthan versus High Court of Rajasthan. State of Gujarat versus High Court of Gujarat. Just look into it.
Pardon. With the lordship permission, lordship directed to accountant and to produce the records or I on behalf of accountant and now the lordship I will take option instruction from the department.
You appear for
I am appearing for the accountant.
we have made some
Your
more.
lordship directed a responsible officer of accountant general to be present.
Present before the court next day.
I like
Because we are seeing many cases where pension is not paid.
that is control of accounts, not accountant general. Here there are two wings in the state. That is control of accounts and accountant general. And control of accounts are the aided in respect of aided school and colleges.
In this case, with who?
I have not distributed copy of that.
But accountant general is not a made party.
No, not a party. But I have. I have not verified the price.
Just if he is your friend, just call him. That court wants him. And you also be here. So that if accountant general is not a party or to be made a party, we can rectify it here unnecessarily without troubling the pension.
Your lordship, I modify that. I am obtain instruction to that effect.
No, how can I modify in his absence? This is online court. Everybody will be seeing. Therefore,
After lunch.
after lunch, you can come and mention. Bring your friend also. No. Yes, sir.
My lordship, may I bless you?
21.
Item 21, my lordship. I have a limited prayer, my lordship. My annexure 3 is pending before the opposite party number 2, my lordship. Is my application seeking for a direction to the opposite party number 2 to a fresh corrected identity card. My lordship, my prayer is page number 6, my lordship. Yes, my lordship. In annexure 1, I have got the identity card that is wrongly mentioned as a 27/6/1982 instead of 27/6/1962. So thereafter, my lordship,
This entry was made when?
recently I have correct date of birth is my lordship 27/6/1982 in annexure 2. That is the proof. Annexure 2 is the proof. And my humble
Annexure 2 is what?
See
That is certificate.
say high school certificates and other certificates.
What are the other?
Is the Aadhaar card, Melchi.
Aadhaar card is not a
High school,
proof
there
of those.
page 12, Melchi.
8 or 9 of the Aadhaar Act.
12 is the high school certificate, Melchi.
Where is that?
Page 12, Melchi.
Yes, my lords, that is there. Annexure 12, page 12, my lords, direct disposal of annexure 3.
3, Melchi.
And it is representation.
Melchi, yes, Melchi.
Be seated.
Melchi.
Petitioner is seeking consideration of his representation at annexure 3 dated. Sit down and answer. This is not a primary school. Stand up and answer. We are all part of the same institution. You are there, I am here, that's all. Which is the date of annexure 3?
11/4. 11/4/2025.
11/4/25. Be seated. 25, wherein he has sought for alteration of date of birth in the records pursuant to, in terms of, he is a SSLC or SCC? What is that called in state?
SC.
SC.
SSC.
SSC certificate. Wherein it is mentioned in page 12. Page 12. Go to 12. Mentioned that his date of birth, what is that mentioned? 27/6/1982. Whereas the records maintained by the respondents reveal a wrong date of birth, that is page 10. Page 10. That is 27/6/1962. 1962. Next paragraph. Learned counsel for the petitioner submits that in terms of the representation, a decision ought to have been taken and communicated to his client, which has not happened. And therefore, a direction be issued to the respondent for consideration. First, next paragraph. Learned AG appearing for the respondents on request of the court, though initially opposed the petition, now fairly agrees to instruct his clients to take a call on the subject representation within 2 weeks, in accordance with law. First, this is a happy thing to happen in adjudication. First, in the above substances, petition is disposed of. Okay. All conditions have been kept up. Obliged. Time for compliance is 4 weeks. 4 weeks, which would include reporting the decision taken on the subject representation to the petitioner.
Yes, please.
Okay. No parts. Okay.
My name will be reflected. Prakash Chandra Das.
Okay. PC Das mentioned. Yes, ma'am.
22.
I beg pardon, my lord, item 22 I will be seen, my lord. But I pray the matter will be taken up next week.
Next week?
Next week, my lord, because of my illness, I could not able to present.
Get well. Get well soon. Yes, call after 2 weeks on the health ground of arguing counsel for the petitioner. Yes.
Item 23.
Yes.
In the year of 2023, the petitioners filed a representation before the BMC officials for approaching the road to the house.
Approach road.
Approach road to the house.
For laying the approach road.
Yes.
They should make a road to your house.
No, sir. The high-rise drain. High-rise drain in front of my house. So I approached for the BMC officer to give a approach road to our house. And I have obtained the plan approval from the BMC, building plan approval from the BMC.
You will put up structure
yes,
at your cost.
Yes.
That they are not giving.
After that, we filed a petition grievance before the Honorable Minister, and Honorable Minister pleased to direct the junior engineer to spot visit and estimate the value. And the junior engineer estimate the value and started the work. At the time of work, the ward number 37, opposite party number 5, stopped the work for his personal benefit. After that, the additional commissioner directly the executive engineer and the South Zone assistant commissioner to joint inquiry report. And the joint inquiry report already submitted before the commissioner.
What inquiry report said?
At a glance, annex, sir.
You have produced that annex?
Yes, sir. Page 28.
What does it say?
It says that it is required. For the purpose of approaching. Yes. But the intervention of that corporator of that area, this could stop. However, thereafter they have filed this representation under Annex 8 at page 30.
Yes.
So with direction, it will suffice.
Do the job. Consistent with the report. Or corporator will say 100 odd things for getting the votes.
Rather they should facilitate.
Report says.
Facilitate the.
We can't be ruled by these people.
And this is pending before the commissioner BMC.
Commissioner BMC. Who appears for him?
There, in fact, panel of lawyers are there.
Issue emergent notice. Learned AG appears for?
I am for the OP number 121 and only one.
Issue emergent notice to the others. Panel counsel, the petitioner is permitted to serve a copy of the petition on the panel advocates, usually representing the answering respondents. Okay. Furnished in detail, something like that. Yeah.
OP number 5 is the corporate.
Corporate.
So if a notice will be issued, then
yes, let notice
it
go
will
to
be
let notice go to him. I last
OP number 5.
yes.
Item 24.
My lord, 24.
Yeah.
My lord, just have a glance to the last order dated 23/7 of 25. I am complying to that order, my lord. Today filing the engagement order and the reinstatement, joining reinstatement of the opposite party number 4 by affidavit.
Your affidavit.
My lord, just have a glance.
There is an order now by brother judge
My lord.
Satapati.
My lord, that pursuant to that order, I have filed that.
You are for respondent.
I am for the petitioner.
Petitioner. Now petition has become infectious.
No, my lord, petitioner, what, my lord? That I am against the order of the education tribunal.
Engagement letter is issued.
No, this is a peculiar thing, my lord, because this is a sort of an arrangement. Because the order is inexecutable order. Because as per yardstick, the post of junior assistant is not involved here. And just have a glance to my annexure 3, my lord. Just have a glance to annexure 3.
Now you join this post.
No, I am for the college, my lord.
You are for the college.
College, my lord, petitioner. Opposite party number 4 is the appellant in the education tribunal. Against the judgment of the education tribunal, I have approached your lordship.
Yes.
In the last order, that order has been passed and I am complying because I am implementing the order.
You are implementing the order.
Implementing the order, the sub-collector is the president of the governing body. It's the government. And we have taken under Annexure 3, just have a glance to Annexure 3, the permission, and thereafter we have approached your lordship.
There is some allowed to move to higher court. What is that?
That is the permission, my lord. Because the college is functioning by the principal, and principal is the to take the permission from the governing body. That the president is the sub-collector, my lord. Thereafter, we filed the writ application, my lord. And the writ application, that the last order, because in the education tribunal, the tribunal has passed the order that you appoint the appellant under junior assistant. That post is not involved at all.
It's not
yardstick. It is a peculiar case because earlier at the time of in the 2014 that the principal which post has not been approved, he has appointed that lady, the opposite party number 4.
In which year?
Post of junior assistant.
In which year?
In 2014.
Then all these years she was there.
In 2014 to 19, my lord, because that post has not been approved. We sought for the approval from the director, government, my lord. But the government has not filed the counter in the education tribunal, my lord. Before your lordship, we have to canvass all those things. Now this is an arrangement.
This arrangement will continue.
This arrangement will continue and your lordship has to hear the matter.
That's what. Till the hearing takes place, this arrangement
will continue.
Learned counsel appearing for the petitioner management.
Government.
Governing
body.
Have filed a memo dated 30/7/2025 accompanied by the affidavit evenly dated and also a copy of engagement letter dated 10/7/2025. First, the engagement letter reads as under. First one. Next, there is a substantial compliance of the coordinate bench order dated 23/7/2025. First time. Call this matter of the 4 weeks.
My lord, as an interim, my lord.
What will be what?
My lord, because that your lordship will.
This will be interim arrangement only, which they have filed now.
My lord.
That will be an interim arrangement.
Yes, because I have filed one application for stay of that tribunal's order. What lordship is true?
No, you have already you have agreed to engage
Yes,
subject to outcome of the petition.
Obliged.
Okay.
Obliged.
Call this matter in the second week of September 2022.
Notice has to be issued to the parties. I will start the copy issue.
Emergent notice.
This is 1 to 3 and 4 will be independent.
Private notice. Private notice.
You will be
1 to 3.
1 to 3.
Yes.
KGA to Mohan 3 appears for 1 to 3, 1, 2, and 3. Issue emergent notice to other respondents.
My lord.
Returnable within the 3 weeks. First of call in second week of September.
Item 25.
My lord, on last occasion, you also directed the counsel for the CBSE to serve a copy. I have already served a copy.
These have been served. I have received that. All these matters, identical matters have been played. Order has been passed to be heard on 18th of August.
18th of August. Similar matters.
Matters.
Do you have
Number.
connected matter numbers?
Connected matter number, I'll provide to you.
Call this matter on 18 along with other connected matters.
I'll provide that after lunch.
May I please? This petitioner is a retired headmaster, my lord. Petitioner has a retired headmaster, my lord, of the aided education institution, my lord, seeking pension.
Retired on which date?
30/4/2023, my lord. 30th April 2023. 30th April 2023, my lord. In this case,
pension is not given to you.
Well, similar matter will also be issue notice posted to
My lord, that Sarat Parida and Chotra matter. While in division bench and this is transferred to division bench, it is posted to 11/8. So any date there are
subsequent to that. On 18/8 we will have this matter.
11/8. The matter is being posted before the division bench.
Correct. Therefore 18/8.
Thereafter.
Any even beyond that, September. Call this matter. Notice is issued.
Notice fresh matter.
Fresh matter.
Similar matter will also be issue notice.
Same order as in
item 24.
24.
No, 24.
No, this is a different. Same order as in WPC. Just modifications in this response and mathematics. 26.
May I please, Lordship?
Yes, sir.
Lordship, for the petitioner, here, I'm the retired assistant teacher of a government high school. I'm seeking for the RSCB benefit. Lordship, in the similar matter, so Honorable Court has Ashok Mahapatra case.
This is posted to 4/8.
4/8.
issue.
All these RSCB matters.
Issue emergent notice. The DGA accepts notice for.
But I am for the opposite party number 1 to 3. For all Miller.
All the
1 to 3.
Call this matter on 4A along with connected matters. Give that WP number. Solve.
Much obliged.
Item 28.
Please, Your Lordship.
Yes, sir.
So this is a matter wherein we have the employee.
From Bhubaneswar Virtual Court. For the opposite party number 1, Millard, I am in caveat.
Yes.
We are hearing for the employer, Millard. Here is a case under Millard, which is commonly known as POSH Act, Prevention of Sexual Harassment Case at Workplaces. Millard, I am for the
that Vishaka judgment.
Yes. That's correct.
Yes, sir.
Millard, here is a case where there was an.
Kindly be louder.
Yes, I'm sorry.
That mic also.
I'll be louder. Millard, here is a case where a complaint was received. ICC, internal committee, complaint committee was instituted. The internal complaint committee found violations, Millard, gave punishment.
But no, punishment.
Punishment was, it's a private organization, so they were asked to leave. He was asked to leave the organization. Now, against that, the accused went on an appeal under the statutory appeal, which is the labor court, under the appellate authority. Now, there in the appellate authority, unfortunately for us, Millard, we had a lawyer, he could not appear. So the matter in effect was decided ex parte. That's there in the appellate court's order as well. I'll take your lordships there.
How long the matter went on?
In the lower court, Millard, I'll have to take instruction how long, Millard. But Millard, my contention is this. Now, Millard, the appellate authority has remanded the matter back to the ICC on 2 primary grounds, Millard. The first being that no local ICC members were present in the ICC, which ultimately decided the matter. Am I clear, Millard?
So it's a requirement, legal requirement?
It is a requirement, Millard. If I may say, as an officer of the court, there is a requirement because it says local ICC. Now, that was point number 1. The point number 2 that the appellate authority decided was that he was not given any right to cross-examine the witness or the complainant.
Whether that right is unqualified.
That's my case, Millard. My humble case before your lordships is that is it. Millard, number 1.
Qualified right.
Millard, first ground is, in fact, there are judgments, Millard, and I can place the judgments of a 1994 Supreme Court, which says there is a difference between principle of natural justice or a violation of principle of natural justice and violation of a facet of principle of natural justice. And the distinction which has been made is, when there is a violation of a principle of natural justice, the entire principle, then it is absolute, as your lordship said.
If facet is violated,
then you have to show prejudice. I completely bow down, Millard. That's my first question. I've got the judgment if your lordship wants, I'll place.
It's a settled position.
Millard, I completely bow down.
Standard book on
I completely bow down.
Principle.
Now, Millard, the second point on which they have rejected saying there was no local ICC members. Now, Millard, on that issue, and hence their corollary is that because there was no local ICC members and the complaint happened in Orissa, in the central ICC team of Zee Telephone, which happens in Bombay, they did not understand Odia, the language. Am I clear, Millard? So there are two issues. Now, Millard, in reply to the first issue, it is our shortcoming, may I say it very clearly, Millard, because our lawyer was not present, so I can't basically better my case. Now, Millard, what happened in the first case is, first of all, the person against whom the allegation is a very high-ranking officer of this particular zone or this particular Bhubaneswar office. Now, Millard, in his list of witnesses, already 2 sitting members of ICC were named. Am I clear, Millard?
Yes.
I have a local ICC. Now, he named 2 of those sitting ICCs as his witness.
Very sitting members of the ICC.
Yes, Millard.
As witnesses.
As his witnesses. As the complainants, Millard, as the accused witnesses. When Millard accused gave us a list of witnesses, he put them as a witness. Am I clear, Millard?
Yeah, the committee members were cited as witnesses.
Yes, Millard. The local committee members. The local committee members were cited as witnesses. Point number 1. Point number 2, the presiding officer of the local ICC or the regional ICC was actually and I've placed those judgments, she was on maternity leave.
Now, my lord, because of two grounds, and the third being that complainant herself was not an employee. My lord, I'll just give a brief background. This is a television channel, my lord. So what they do is they also hire actor or actresses on, my lord, basis of contractual basis. My lord. So she not being an employee, what she has actually done is she has written mails, my lord, as is usually happens, from top to bottom, including the MD of Zee Televisions in Bombay. And my lord, this being a sensitive matter was immediately picked up. Immediately mail was sent to the presiding officer of the local ICC. She immediately replied back saying, I am on maternity leave. So looking at the gravity of the offense, immediately an ICC of Bombay was set up. Now, my lord, on the second ground of they not being well versed with the language, my lord, the ICC report would show, and I'll take it to your lordships, that not only it was clarified to all the witnesses along with the complainant and the accused that are you comfortable with the language Hindi? Are you comfortable with the language English?
They said yes.
Yes. Not only that, it is recorded. Number two, their statements were transcribed, sent to them on email, and they have confirmed in the email that yes, it's true. Am I clear, my lord? Now, my lord, all that kept aside, coming back to the point of prejudice. Yes, my lord, there is no cross-examination. I must confess at the threshold itself.
Your case is it's only a facet of principle.
Number one, my lord. Number two, my lord, I'll take your lordships to the ICC. One of the allegations, my lord, again, I'll not want to discuss it in open court. My lord, there were 5 allegations. 3 have been rejected by the ICC, saying that the complainant could not prove it. The 2 which they have found him to be guilty. One of them being he has admitted that he has put certain or made certain messages or comments on her social media page, which was confronted to him. The printouts were confronted to him. He said, yes, I have sent it, but was not my intention. Now, my lord, I have also got I may not be able to place it, my lord, because it might only be of a persuasive value to your lordships, my lord. A single judge of a Madras High Court, my lord, very recently in January of 25, dealing with a similar issue it's been opined that the question of intention cannot be gone into when it's a report of a proceeding under the POSH Act. It could be gone into when it is a criminal offense arising out of that. But when it is under the
mental element is not a point.
I completely agree. They have said that the act itself is what has to be seen, not when you can't go into the intention of it. And my lord, so the ICC found in its own wisdom that once you agree, you being in a position of authority, you should have behaved. You are required to behave in a much better.
5, 2 are proved.
I completely wrong. My lord, 2 are proved. 2 are not proved. And 1 was they found out that because I'm not also going there. And 3rd was also proved, my lord. 2 was not proved. 3 was proved. 1 was it out of the fact that one particular person, there was an eyewitness to an offense. I am saying even if I keep it aside, 2 have been admitted by him. So there is no prejudice at all. Somebody saying that I could have cross-examined it. And my lord, also judgments are clear as to in POSH Act, to what extent would cross-examination be allowed?
Of course, that's a qualified right.
I completely agree. And here, my lord, another thing what the ICC has done, they recorded the statements of the complainant, sent it to the accused received it, and then replied back. No, not even one email through while the ICC was going on, saying that I want to cross-examine. Not one.
But the law is that you should ask whether
I completely bond.
You intend to cross-examine.
I completely bond. My lord, because my reply to that, my lord, is because it's a sensitive issue, what was followed by them was they recorded it, gave it to him, and he replied to it. My lord, no. So after that, he has never said that I want to cross-examine it. And it is only an afterthought is my case, my lord. My humble case is it's an afterthought where in appeal they have taken so. And my lord, in the appeal, because of our shortcoming, my lord,
in the original proceedings, nowhere he said I want to cross-examine.
No, not even a single email. They can't even produce it, my lord, where they said that I want to cross-examine. Nor did he ever say.
What is his qualification?
What was the post, my lord? Yes, my lord. My lord, it's at, my lord, may kindly see at para 3 I have made. He's the associate director programming at the local television channel.
But is he standing in life?
My lord,
He's standing in life.
my lord, I have to take instruction. What was his qualification? I'm sorry, my lord. I only took instruction as to what his position in the company was.
Now what happened?
No, my lord, I am against that order of the appellate authority, which has said remanded it back. So I am before your lordships on that. They were on caveat, my lord. I've already given them a copy. I've also stayed, my lord, otherwise.
Yes, brother.
Millards, yesterday night only I got a copy of the net application. So I have not ample time to go through it, and I require to file a counter if your lordship permits me, so that the contentions which were raised by my brother can be effectively dealt, and your lordship can also effectively decide the matter.
But till then, don't precipitate the matter.
Yes, sir.
The remand shall not be precipitated. The order shall not be precipitated.
Well, there is an order. So, my lord, if that can be stayed, my lord, subject to your lordship's image.
The matter was remitted back to the ICC for fresh hearing, giving opportunity to both the parties to make their submissions and giving opportunity to both the party to cross-examine each other. And that was for that reason, all the grounds which are then taken before your lordship, they were given sufficient ample opportunity before the appellate authority, lower appellate authority, but they deliberately avoided, my lords, even after appearing in several occasions, they took more than 7 adjournments and they did not appear, did not file the counter, and they are all filed all new documents before your lordships, which are not part of the ICC findings. They have even filed the Annexure 1, which Annexure 2, that was also not a part of the ICC findings. They have brought new documents before lordship. And
you want to file objections or you want to argue?
Yes, lordship. Lordship, I will file objection.
The other day to argue again this one. Whatever now you have argued, I will not permit to repeat next day.
I will file a counter in detail so that your lordship will effectively deal it.
First time matter has come.
Well, it is fresh matter.
Issue notice. Respondent has entered caveat. Only one respondent.
One matter. I am very respondent.
I must say that with a heavy heart, my lord, what has happened is, my lord, in the appellate authority.
Now, how many?
There are a lot of performers, including the members of the ICC and the complainant herself. They have also made her a party. My lord, what I wanted to bring to your lordship notice that also I went through another judgment which said that the names of the
they cannot be made.
But unfortunately, I had to make because they had made it before the appellate authority. So they are all performer parties, my lord. So he's the only party who has to give reply.
You file a memo saying that they are pro forma parties and therefore notice be dispensed with.
My lord, I have made it as performer. I'll make the memo, madam.
Issue notice to which respondent?
Respondent number 1, madam. Opposite party.
First respondent. First now. The first respondent has entered caveat through his counsel, who has made some submission. First. However, he seeks a short accommodation to come out with his pleadings to resist the petition. First. Next paragraph. Call this matter after 2 weeks. 2 weeks?
Yes, Lord.
3 weeks. Call of 3 weeks. 3 weeks. As requested by the learned counsel representing the caveat respondent. First. In the meanwhile, the proceedings in terms of remand order are kept at a break.
Remand order dated
Till next date of hearing.
The order was 35/2025 of the appellate authority.
Appellate authority's order.
35/2025.
The proceedings take this. Pursuant to impugned order dated 25
35/2025.
May 2025 at Annexure
7, madam. I'm sorry.
Or kept at a bay.
Deeply blessed.
Next date of hearing.
Deeply blessed.
Can you mention your name is?
My lord, Satya Mohanty, my lord. S.S. Mohanty.
Heard learned advocate. Senior advocate?
No, my lord. I'm
Senior learned advocate Mr. Mohanty appearing for the petitioner and learned counsel Shri and so appearing.
S.K. Das.
Santo Das.
paying for the chemicals one. Yeah. Next.
Item 29.
My lord.
Yeah.
My lord.
But one thing, right to cross-examination.
Yes, Lord.
Like Wellman on cross-examination, famous book.
Yes.
Iyer and Iyer on cross-examination, Indian version of that.
Yes.
They say right to cross-examination is a very important right. Right from the days of Socrates.
I completely pardon.
Not just say that person is not prejudicial, but there are some judgments which say violation of principles of natural justice per se is a prejudice.
I completely.
For example, I tell you that judgment that was 1980 S.L. Kapoor versus Swine, so 1980 Supreme Court. 79 or 80 Supreme Court. Just look.
I completely. As your lordship, no rule can be absolute, so I'm just trying. Yes.
Yes, Lord.
Yes.
My lord.
Yes.
I was placed on the suspension, my lord, on 11/2/2020, my lord. Annexure 1, my lord.
11/2/21.
11/2/2020.
2020.
My lord.
What are you?
I am junior clerk.
Junior plus one.
Junior clerk, my lord. Junior clerk, my lord. Then, my lord, charge was framed, my lord, after 8 months, 14/10/2020.
What short memo was issued to you?
My lord, charge sheet was issued. After 8 months. 14/10/2020. Thereafter, my lord, in the meantime, my lord, more than 5 and 8 months has been passed. And subsistence allowance, my lord, you have paid 50%. But I have entered
6 months it is paid 50%.
Yes, my lord.
Then after
75%, they say for the time being they have paid, now it has been withdrawn, my lord. That is there, I have annexed. I am coming to that.
It is withdrawn.
Yes, my lord, withdrawn.
Subsistence allowance is withdrawn.
75%.
They have made it 75%.
It was extended for limited period 75%. And that has been withdrawn. That is, I have annexed. I am coming to that. Then, my lord, Annexure 3, my authority wrote a letter to the Vigilance Department because FIR has been lost thereafter, my lord. Annexure 3, page 24, my lord. 14/1/2022. For reinstatement into service, they need NOC from the Vigilance Department. Let's see, page 24.
This suspension was because of detention beyond 48 hours.
Yes, my lord. Fourteen 2022. Thereafter, another letter was issued, reminder, that in 19/6/24.
Now, how long suspension can? What is the latest judgment of the apex?
3 months, my lord. Ajay Chaudhary. Yes,
Latest.
Ajay Chaudhary. Yes.
Ajay Chaudhary.
My lord.
2017 Supreme.
No, 2023, one more judgment has come now.
That is reliable on Ajay Chaudhary, my lord. They will go for another, then search for the instruction, the extension.
That must be review, my lord.
That must be a review.
Periodical review.
Periodical review.
Whether to
yes,
continue or not.
That was decided in Ajay Chaudhary Kanji in details.
Whether review has been done in this case.
No,
Nothing
first time it has come in the
First time it has come.
Issue emergent notice. Learned AGA on request accepts notice for
There, my lord, 1 to 4.
all respondents.
Yes.
All respond.
All respond. First one. What is the charge?
Charge, my lord.
Charge is, my lord,
That is
the amount government money which has been fraudulently withdrawn, which is around 1 crore 71 lakhs some odd.
not by me, my authority. I am the clerk. I am not related to that disbursement also.
That money withdrawn and paid to whom?
Paid to beneficiary, retired pensioner.
But your hands are clean.
No, I am no your concern. I am not deal with that file also.
Okay. You did not.
Because I am the employee under the DDO.
After 2 weeks. Okay.
There are subsistence allowance to be paid. at the rate of 75%, which they have paid earlier.
How long you keep employees
Placed under suspension by paying the...
and you pay the public money?
Yes.
And he will enjoy.
Let me come with the positive response.
That's good.
Next short that your lordship. Because I have the lodge of retirement.
Of August 2025. Update.
How do you go for August?
August.
Well, can it be that substitution allowance?
Normal, it should be paid. Normal, so far the
Normal 50%,
so far-
75% they are paying. Lordship that has been revoked. Lordship may see that.
Yeah, let us see. Let us see.
Oblige.
Item 30.
Next day, brother, look into
No, I look at it.
subsistence.
I am conscious.
How he should survive. Suppose tomorrow in the disciplinary inquiry, what happened to disciplinary?
Nothing else. My lord, I have a number of times I have given the representations to provide the document. They are not providing. And that has been superseded also. That is there on the call. Annex 3.
Okay.
Oblige.
Item 30.
My lord, this the coordinated bench had a passed order by the Annexure 15, page 76. Order dated 19/3/2025.
What it says?
Here, my lord, the impugned order, 1 minute. The impugned order, which has been annexed to this application by virtue of this coordinate bench order, this has been well rectified and also issued on last Thursday, my lord. The copy also, if at all my learned senior friend has not got it, then I can serve it now also.
Yes, give copy.
See for the movie for that was.
Have you received that?
No, I have not given it.
You received
Only
No, my lord.
only on that
Why can't you look into the version pursuant to that order? You may not.
that we have complied. Let them challenge this by way of
Somebody gives even a bus ticket. We should just look in.
No, the OP number 2 has given comments against the Honorable Court and Honorable Apex Court. The Honorable Court and Honorable Court have passed the matter.
He does not want to look into. I will look into.
Now see for the moment, page 83.
No, I will see this first time, then I will hear.
Let me clarify for a moment. In the averments in para 2, sub para 2, that was a finding that it is judgment in personam. So it is not applicable to this. That was it. By virtue of this honorable court's order, with the due regards and emulation, this has been rectified and issued the order. Let them challenge the same, absolutely on merit.
Give that. I will look into. It's not a judgment in rem. We have been taught in law school. The judgment in rem under section 43 of the Evidence Act are rendered in 4 jurisdictions: matrimonial, admiralty, insolvency, and one more is probate.
Probate.
These are the 4 jurisdictions. The 5th one is where the constitutional court strikes down legislations or instrument of law. Every time a citizen cannot come, quash it in my case also. So once it is quashed, it's rate lordship. These are the 4. What was the order to take up the doctrine of per incurium, principle of per incurium, etc.? So modified order has been issued now.
Exactly, madam.
To what effect?
Only to that extent, so far this judgment which is being covered and they have challenged the same, that is the judgment of Krishna Chandra Panda of this honorable court, my lord.
Yeah.
That in the para 2, it has been reflected that it is not judgment in rem, my lord. That we have clarified, my lord, and already order has been issued in pursuance to the order of this honorable court. Dated mail order.
Order issued to what effect? Dated 19/3/25.
Yes, ma'am.
Pursuant to that, you have made an order now.
Exactly.
What order you have made?
29/7/2025.
29/7/25. 25/7/25. 29/7.
29/7.
Today. Sorry, day after yesterday.
Yesterday. That already issued. Also, I have served the copy also right now. They
No,
can
that order, whether does it make any justice to him?
No, again rejected.
It does not.
But
That is on merit, my lord. That is on merit.
That's of the opinion.
That wording was subsequently changed by virtue. That should not be there at least where it has been placed. My lord. All other things are merit, my lord. That will respond to this.
All right. Then you don't want to look into the matter?
I have served
Copy now.
No, page 83 of the writ application, I am reading that para 4, the previous order, that the petitioner has relied upon the order dated 16/9/60 of the Honorable Tribunal passed in the way number Sasana and a bench. Page 83.
Page 80.
Para 4.
First in way number 3885 of?
Yes, of 12 and bench. In this context, it is pertinent to mention that being agreed with the such order, the state approved the Honorable Court by filing WPC number such as the Honorable Court without going into the detailed issue.
You have not filed the objections, has it?
No, my lord, it is a fresh matter. On that, it has to be rectified. Then I will respond to that.
Then the merit of the case dismissed the writ.
All right, we are issuing notice.
Yes.
Still you want to argue?
No, the court that bench has sought for instruction why it is not referred to the Supreme Court. Because he is given comment to the Honorable Supreme Court. Now the next part, dismiss the merit on the ground of gross delay and laches. Further, the order dated 28/10/21 passed in WP such and such was a challenge by the state before the Honorable Supreme Court with the SLP such and the
Don't you take
the same also dismissed without proper adjudication.
In that particular rejection order also, in the last part also.
Anyway, whatever you
I will come with the rest.
see it in writing.
Exactly.
So that he will go through and he will be able to answer. Learned AGA. What's up notice for correspondence?
Opposite parties.
Opposite parties.
Terminal all respondent 1, 2, 3.
The opposite parties.
Call this matter on 21st of August 2025. Okay.
Item 31.
Same order.
This is on 4/8.
For it. Issue notice. Call this matter along with vulnerability and subnotice correspondent. Call this matter along with that. Yes.
Item 32.
32, Your Lordship, on behalf of Soma Patnaik, I pray for 2 weeks time.
Doctor, you have to be little louder.
I pray for 2 weeks time. Your
You
Lordship.
want time?
Yes.
Other day also you took time.
No, Your Lordship.
You did not take. First time you are taking.
Yes.
What's the grounds?
Your Lordship, the conducting council is unwell today.
Not well. Call this matter after 2 weeks on the health ground of arguing counsel appearing for the
Petitioner.
You are the opposite party. Yes.
Item 33.
My objection. Here in this case, the petitioner's wife was working like a government school teacher.
Make use of mic. 2 mics we have kept now. At least one you should be able to use.
The petitioner's wife was working like a government school teacher, my lord. He retired in 2009 and get the pension expired on 2/3/2024. His wife, being the nominee, has applied for the family pension, my lord.
Who? Husband is
Husband of the
family pension.
Family pension.
Husband is entitled to family pension
Family pension, my lord.
under the rules.
My lord, under
Which-
those, the PPO is also there.
Huh?
I have annexed the PPO.
pension PPO. But then it stated that after death, he will get the family pension, my lord. The husband of the petitioner. Accordingly, he applied. But what happened, my lord? His application has been returned back on the ground that the surname in the
Change of
surname in the PPO and surname in the death certificate are different. Because at the time of employment, his as per the matriculation certificate, his record was reflects that day, Jyotirmoy day. But after marriage, he used to change his surname from, as per his husband's surname, Mishra minor. His her Aadhaar card.
Yes, brother, what it is, ordinarily in our society, the wife adopts the surname of the husband. So even a child will know this. Yes, my lord.
Common occurrence.
Take notice. Yes, my lord. We'll call this matter next week.
I will also want to take notice on OP number 3 and 4, bank manner. Bank manner.
He is also part.
He is for 1 and 2, state.
1 and 2. Emergent notice to other OPs.
Can I request one thing, my lord? One Mr. Gurudat Kara, advocate, senior advocate. He is appearing usually for the State Bank of India.
Taking usual steps. Petitioner is permitted to serve copy of the petition on the panel counsel appearing for.
Mr. Gurudat Kara.
Whoever, I don't know, not panel counsel as well. Okay.
He said that's
4 weeks.
Item 34.
Pardon.
Yeah.
My lord, in this case, due to inaction of the opposite part number 2, the petitioner filed his writ applications. The case, my lord, fact of the case, petitioner is a legally married wife of the opposite part number 3. Petitioner number 2 is a son, minor son. The date of retirement of the husband, my lord.
There is no culture in this bar to use the mic.
No, my lord.
My lord, that mic in a usable form. You have put this with so much distance. How can they make use of that? And so many people disturb the court.
The husband neglected the wife and his son. In this regard, petitioner filed and the application before the family judge Raurkela for maintenance. That petition also pending. In this regard, petitioner going to retirement in the year of 2026, January 2026. In this regard, the wife filed a reprehension that is a 22/4/2024 by the annexure 4 for some amount to be not disbursed in favor of the petitioner. That application pending till date, but not disposed of.
Not to pay the husband.
No, not neglected the petitioner, not
you
paid.
Still 125.
125 petition, my lord, that is a annexure 3, my lord. That is a pending.
No, you get order there.
My lord,
We direct the magistrate.
I will not try to stay. My simple prayer, my lord, the Honorable Court may be directed to OP number 2, District Education Officer, dispose of my reprehension pending before by the annexure 4, my lord.
What's your right? It is his earned money. You can seek maintenance elsewhere in accordance with law. How can you ask the employer, no, he has to look after me, he is not looking after, therefore don't pay him the money. That power is not there. You are right. But where is your right?
Yes, my lord, sir. They rejected or allowed. This is a separate matter.
No, you will send a representation to the Registrar General of this court saying that you pull down DIXIT's court. Should you consider that? What is your right? Prima facie right. You should have prima facie. No right, no right. Simple. Even my pencil has fallen down in blue.
My lord, what is the position of annexure 3? My lord, I take instruction. The annexure 3, the criminal proceeding, is it disposed of or not? Next week or after week?
Learned counsel, having argued the matter for some time, agrees with the proposition that no right, no writ, and that the petitioner, being the wife, cannot ask the employer to stop paying salary to her husband, who is an employee. Personally, such a right is yet to born in Indian jurisprudence. First up. Next paragraph. The above being said, justice of the case warrants that the criminal proceeding case number 7 of 2024 needs to be heard and decided by the
107, my lord. 107, case number
107.
My lord.
107. Give that. What is the name of that case?
Criminal proceeding number 107 of 2024.
Criminal proceeding number 107 of
2024. Under section 125 CRPC.
Filed under section 125 of first file CRPC.
Pending before the Lord Judge.
Pending on the file of
Learned Judge Family Court Raurkela, my lord.
Learned Judge Family Court Raurkela. Within an outer limit of 6 months. 6 months. After affording opportunity of hearing to all the stakeholders. First of all contentions are kept open. First of registry to send a copy of this order to the family court concerned by speed post immediately.
As for submission, my lord, if it is money is disbursed.
What can be done? You seek order there only. You seek order at the hands of the family court. Family court can make that order. Not Justice DIXIT. He has many limitations here.
Item 35.
Yeah.
May I please read? In this dismissal, my lord.
Is over. 34 is over.
May I please lord?
Yes, sir.
In this dismissal, my lord, I am challenging the inaction of the opposite party in not providing, my lord, in increment for the annual period, my lord. That is, my lord, 1/3/2020.
What is that mandamus to consider the representation?
I have annexed that, my lord, under Annex 6, my lord. Opposite party number 4, to consider my application. He has not taken any action.
In the application.
My lord?
What you have sought for in the application? Application में मांगनी क्या है? Correct.
Application for initiation of sanction of disbursement of increment of annual notional benefit.
Yes, you can. Petitioner seeks an innocuous prayer, makes an innocuous prayer for a direction to consider his representation. Annexure A6 addressed to the district education officer Sambalpur, wherein he has sought for grant of certain increments. First one, Learned Counsel for the petitioner submits that Article 350 of the Constitution of India mandates consideration of such representation and granting redressal to the grievances aired therein by the competent authority and within a reasonable time. First one. Next paragraph. Learned Counsel, Learned ASC appearing for the answering respondents of OPs, having opposed the petition, now fairly agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation within a reasonable time, comma, if all contentions are kept open. First of all, this is fair and reasonable. Next one, in view of the above, petition is disposed of. Time for compliance is 6 weeks, which would include reporting with the result of the consideration to the petitioner hearing. First up, it is open to the answering respondent to solicit any information or document from the side of petitioner as are required for due consideration of the subject representation. Semicolon. However, in that case, delay shall not be what? Of course.
36. May I please, Your Lordship? Petitioner challenges the order under Annex 5. Your Lordship, at a glance, that in inviting a reference to the subject and letter cited above, I am to say that the resignation withdrawal letter dated 13/1/23 of Sri Manish Ranjan Naik X data entry operator is rejected on the basis of your inquiry report dated 29/5/23. Your Lordship have a glance to page 18, Annexure 4 series, last paragraph. As the appointment in the post of data entry operator is contractual in nature and Sri Nayak served a period of 10 years and 7 months in the said post and render good service and no adverse remarks is found in his entire period of service. If permissible, his request for withdrawal of his resignation letter may be considered and Sri Nayak may be issued re-engagement order to continue in this former post.
Yes, brother. He wants to withdraw the resignation letter. It is not yet accepted. Apex Court says resignation letter can be withdrawn anytime before its acceptance, unless the rule says the contrary. For example, the judge is resigning. We cannot withdraw that. Once it is sent, we resign. But here, employee is entitled to withdraw the resignation at any time. And Apex Court said in 2 decisions, even after acceptance also, there may be cases where withdrawal has to be accepted. Because life itself is like that. Life plays games with us. At times we fall on thorns of life and I bleed, said the famous poetess Shelley, P.B. Shelley. I fall on the thorns of life, I bleed. And take notice.
Yes.
Number that is returnable within 2 weeks. But don't, in the meanwhile, don't accept a resignation letter. All right. Otherwise, you may accept the letter and you may say a fresh cause of action. The respondent, answering respondent, is restrained from accepting the resignation letter since already there is a request for withdrawing the SIP. Okay.
I think that is when
Petitioner are seeking relief as per the judgment of a court next bench, my lord.
Will issue notice. They have to look into that. Or is it covered by the matter?
Other matters, my lord, she posted to 11/8.
11/8.
My lord. No grant, my lord, claiming for pension.
Okay. Issue emergent notice. The DSC accepts notice for the all respondents. All respondents.
All the respondents.
All respondents. Call this matter along with the WP number.
My lord.
Give that
Sharp copy, extra copy to government council, man. All the government.
Just give the number. On 11/8.
11/8, my lord.
Along with the related matters. Okay.
Item 38.
May I please address? The petitioner initially was appointed as a Swachhasevi Shiksha Society in the year 2006. But while continuing as such, by Annexure 2, a list was prepared for promotion of teachers from level B8 to level B, my lords. My serial number is what? Page number, my lords, 13.
Your representation is Annexure 7.
7, my lords.
Let them consider that.
My lords.
What you have sought for? For promotion you have sought for?
Professor, my juniors has been promoted from the earlier date. I have got that term.
Petitioner is knocking at the doors of Read Court, aggrieved by non-consideration of his representation, dated 15/1/2025, a copy whereof avails at Annexure A7, wherein he has sought for promotion to the higher level on the ground that the juniors have already been accorded such promotion. First off,
Juniors get earlier, I got letter. I got letter on my lords. I got the promotion letter.
Therefore, earlier date has to be given.
My humble service.
First. The net counsel for the petitioner submits that although the promotion on par with the juniors has been given, the effective date of promotion needs to be antedated. First, next one. Learned ASC appearing for the official respondents opposes the petition, making submission in justification of the stand that the date allotted to the petitioner for purpose of promotion is perfect. First off, having so contended, now he agrees to instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way. Should all contentions be kept open? First off, this is fair enough. Next paragraph. In the above circumstances, petition is disposed of. So, prescribing a period of 8 weeks for consideration of the subject representation and to convey its result to the petitioner as well. First off. Now, no course.
39. May I please, madam?
Yes.
Item 39, my lord. Direction. Petitioner seeking for a direction to release family pension, my lord.
Family pension, they are not given.
No, my lord. That is, this matter is covered under the judgment of Hemant Chotrai case. That has been fixed to 11/8.
11/8, lord. She posted to
11/8. Issue notice. The ASC accepts notice for the respondents. All this matter along with connected matters on 11/8.
11/8.
Take this. The connected number to be given. You put, see, I am pulling the matter so that one order will dispose of and do justice to many. Otherwise, every individual order, like reinventing the wheel again and again.
Yes, ma'am.
Yes.
Item 26, my lord. Similar matter, item 26. That is
26 also.
Yes.
26. 26. All along with WP number 26.
Item 40. 40, my lord. Permitted to withdraw.
Permitted to withdraw.
My lord.
Why? Not happy with the court?
No, my lord. Fact is that Infosys, I have given already memo in the morning.
For the petitioner had the memo. Date. Today's date.
Pardon?
Today's date.
Hello.
Date. Signed. So, which reads as under. First, next paragraph. Yeah, have you any objection for withdrawal? ASC appearing for the respondent signifies his consent for grant of leave. First, next, in the above circumstances, petition is disposed of as having been withdrawn with no liberty to adjudicate on the same condition. Okay.
Item 41.
May I please, your lordship, this RSP posted to 4A, bunch of cases, your lordship.
Show emergent notice. Learned ASC accepts notice for the respondents for this matter along with connected matters on 4A.
Item 42.
Item 42, made precedent.
Yes, sister.
Lords, here I am challenging the order of rejection of my appeal, by which my order of termination, by which the order terminating my services have been upheld. Lords, may I just place the facts before my lords?
Termination is dated 6/6/22.
2022. And the 22/2025.
28 February 25.
Annexure 1.
Why you were terminated?
My lords, I was terminated on the ground that I had taken leave in the year 2019 on the ground of poor health of my father. And
2019.
2019.
How many days?
My lords, for a period of almost 1 year, consecutively I was filing leave applications. It was being received by the block education officer who is my...
1 year.
My lords?
More than 1 year.
More than 1 year, my lords. Admittedly, more than 1 year. So, my lords, what the authorities do...
What are you?
My lords, I am an accountant. I was posted as an accountant come support staff in the block education office.
How many children your father has got?
My lord's only son. That also I have stated in my leave application. Only son. Yes. Your lordship may see the leave application.
Father and mother are aged what?
My lords, my father is more than 65 years because the present petitioner is almost 41 years old. He also has 2 children of his own. And he is the only son. Leave application is at page 20. And my lords, my humble contention is that the authorities have not followed the OPIPA rules. My lords, because I am a contractual employee, my lords, may kindly see the rules. I'm giving a copy of the regulations.
Yeah.
If your lordship will just take. Your lordship may take rule 33.
What it says?
Page 31. Page 31, rule 33, subclause 3.
Subclause 3 says that in case of employees who are working on contractual basis, and if they are guilty of any misconduct, the authority has to first ask for explanation. And if the explanation is not found satisfactory, then approval has to be taken by the appointing authority. Then show cause has to be issued as per Rule 28 of the rules. Here, my lords, no, it has not been followed.
Yes, you are like P.T. Usha.
No, my lords, I'm sorry. I'm sorry.
You have to take aged men also.
I'm so sorry. I'm so sorry. I'm so sorry. My lords, I am reiterating.
So this procedure has not been followed?
It has not been followed. They directly issue me the show cause. So I file a writ application. This Honorable Court directs that
show cause should be preceded by the sanction of some authority.
No. This Honorable Court directs that first see whether the show cause is valid or not in terms of Rule 33(3) of these regulations.
No, this show cause notice you can show cause.
I have already done that.
Yeah, then if they take a decision, then you will have cause of action.
No, my lord, already decision has been taken.
Taken now?
Yes, my lords. Decision has been taken. They terminate me. What they do, your lordship may see the termination letter.
Anyway, take notice.
Yes, my lords.
You appear to be very belligerent. Yes, urgent notice. Who appears for respondents?
The state.
Only state. All for all respondents. You are not all, my lord.
Only 2, I think.
Take that. For 2 notice to go, my lord. State project director, you appear.
No, I am not appearing for a paper, my lord.
You be louder. Grab that mic near.
Except 2, my lord, or 2 other respondents, I am appearing.
Issue the learned AG accepts notice for respondent, except OP number 2, to whom emergent notice is issued, returnable within 3 weeks. Then the sentence you have to add, na? That will be PJ or something like that in your course. Yes.
Grateful, my lords.
All right, we'll come afterwards.
I mean, pardon, item number 1 has already passed by. And it's on the present.
Your friend has come. He was saying, your friend was saying that AG office is not a necessary party or necessary party?
Not necessary party.
Not a necessary party.
No cause of action arising.
He may call for the pension papers from the concerned, so that it can be done.
Account section.
There is no direction, also not party in this proceeding. Your lordship may direct the accountant general to call for the pension paper from the concerned department.
And this sort of
You're not party in this.
Okay.
Ultimately,
of the accounts office, we can say. Yes, AG, Mr. AG.
AG means advocate general or accountant general?
Yeah, accountant.
Accountant general.
I am appearing for the accountant general.
The separate panel.
But that office is not concerned with this case.
No, that office still in this case.
Yeah, that.
Well, pension paper has not been submitted till date.
That we'll look into. That already he has admitted pension papers are already submitted. Yes, let us see.
Call for the pension paper has not been submitted.
Let us see. That day, some officer will bring the file and tell us.
I will.
But you said that pension papers have been submitted. Yes.
I will take instruction to that effect.
All right.
Modify the order.
But what order modify? You are not a party only. Some official will come, don't worry. Yes.
I will obtain instruction and convince your lordship.
How? You are not made a party.
Your lordship can direct.
Will direct to make AG office a party.
Well, ultimately the
AG office has to decide.
Yes. So let him make a party.
Petitioner is
oral prayer, your lordship can.
Petitioner is directed to array office of the Accountant General for the state of Orissa. Where that office is? Bhubaneswar. As a additional respondent number. See that, which is that respondent number. So and so. Make it now.
I'll amend the cost type.
Yes, amend it.
In the meantime,
He's the
learned panel counsel, Shri. Right. So, accepts notice for the respondent AG office. First one. remaining order will remain. The remaining order, it remains. Some official you have to send.
Your Lordship, I will take the instruction of officer unless you say officer, I will take instruction. Why that doesn't say I am not sanctioned. The position I will convince you, Your Lordship.
You will ask, but I will not make that written order, but keep somebody present here. Because you can't harass retired people.
No, that's not a harassment. Perhaps that is communication.
Let us. You that fine. You that fine. This line, you can, the last 2.5 lines, that you can delete. Learned panel counsel appearing for the AG undertakes to answer all the questions and also produce necessary documents on the next date of hearing itself. First off. Call this matter on 1/8/2025 for further hearing. Okay. Yeah. You I'll check it. Until government and AG officers, so far as I am concerned, delaying terminal benefits, non-payment of salary, unnecessarily harassing the employees, I will levy 1 lakh rupees cost or sometimes 5 lakh rupees cost, I tell you. That should never happen. Because they are pensioners, they should not be put to trouble. Family, children will be there, payment of installments to the housing loan. And at that day, generally BP, sugar, kidney, lungs,
marriage of their son, daughters.
Come. Therefore, you should not do that.
Item 13.
I'm just waiting for a good case where I can put a very big bleeding cut. Yes. I'm just waiting for a good case to come with all pleadings and other things. Yes.
Item 13, pass over.
What is this matter?
Here, the petitioner is working as a reader in political science in an aided institution. This claim for placement into the lecturer group A as well as reader scale of pay retrospectively with effect from 16/9/2008. That is as per the law decided by this court on Annexure 6.
That is not given to you.
No, man.
Who are the respondents?
State OP number 1 and 2.
1 and 2.
1 is the authority which is to grant because he has made a representation and accept.
But we'll direct them to consider the representation in the light of this judgment.
Annexure 6 series.
Okay. The short grievance of the petitioner is as to non-consideration of his representation dated
7/2/2025.
7/2/2025, a copy whereof awails at
Annexure 9.
Annexure 9, wherein he has sought for
placement. Placement into lecturer group A as well as reader scale of pay retrospectively. I mentioned in the representation.
Placement and fitment of pay.
Yes.
As a lecturer group A.
Yes, as well as reader, state scale.
And also as reader into brackets, state scale of pay. State scale of pay. With retrospective effect from 16/9/2008 and 16/9/2018 respectively, in terms of a coordinate bench decision, division bench decision of this court in Chittaranjan Das versus State of Odisha, WP number 8976 of 2017, disposed of on 3/4/2023, and also Dolamani Meher versus State of Odisha, WP number 4312 of 2016, disposed of on 6/7/2023. Okay, just one there you can look into. Everything is available. Next paragraph. Learned counsel for the petitioner argues that Article 350 of the Constitution mandates that the consideration of representations should happen in accordance with law and within a reasonable time. Semicolon. This having not happened, his client is knocking at the doors of Red Court. Full stop. Next paragraph. Learned AGA on request appearing for the respondents opposed the petition, contending that unless a concrete right is demonstrated from the records, the rule of no right, no writ becomes invocable, and therefore no relief can be accorded to the petitioner. First, having so argued, now he graciously agrees to instruct his clients to look into the grievance of the petitioners as has been aired in the subject representation in accordance with law, should a reasonable period be prescribed, keeping open all contentions of the parties. First, this is fair and reasonable. Next paragraph. In the above circumstances, this petition is disposed of. First, time for compliance is 8 weeks, which would include the time to convey the result of consideration to the petitioner. First, it is open to the answering respondent to solicit, etc. Same paragraph, just put it, print it. Okay. Now, no costs.
Item 43.
What is this matter, sir?
My lord, this is a case of RSP, my lord. It is posted to 4/8, my lord. Hearing.
Straight to
4/8.
Issue notice. Learned AG accepts notice for the respondent. Similar matters are stated to have been posted on 4/8, and therefore call this matter along with connected matters on the same day.
Item 44.
44 also same, man.
Same.
44 regarding
Same one.
45.
Yes, sir.
But the claim of the present petition and the present writ petition is for grant of pension, although he is an employee upon block grant added educational institution. But the similar matters have been posted to
11/8.
11/8. Issue notice. Learned AG requested to accept notice for the respondent. Call this matter on 11/8 when other similar matters are posted.
46.
May I please your lordship?
Yes.
Lords, here, petitioner number 1 is the father, petitioner number 2 is the son.
First petitioner is father, second petitioner is son.
Son is the adopted son. Exactly, adopted son. Petitioner belongs to police by caste, scheduled tribe. He has adopted a son from a non-scheduled tribe. So that reason, my lords, he was adopted at the 3/4 and a formal adoption deed was registered in 2006. In the meantime, he has completed MBBS course and is pursuing post-graduation. At that time, his caste certificate has been cancelled on the ground that he, being a non-scheduled tribe, having been adopted as a scheduled tribe, the caste certificate has been cancelled. But if your lordship will kindly see, apart from anything, a circular of the Government of India, Annexure 11, page 102, minutes.
Yes, he is decided by birth.
Minutes.
Mahabharata says, in Mahabharata, it is said, Daiva yatnam kule janma, Purusha yatnam paurusham. Your caste is decided by birth.
But people are, let me kindly see this Government of India circular at page 102, case of adoption at last 3-4 lines. Great care has to be exercised in dealing with cases where a person claims to be scheduled caste on the ground that he has been adopted by a scheduled caste person. The validity of adoption has to be clearly established before any caste certificate can be given. It is for the party to prove his claim by cogent and reliable evidence.
At what age he was adopted?
Because
What age?
at the age of 3-4. But formal document is executed at the age of 9. Entire evidence on the collected shows from 3 to 4 years he was adopted by the adoptive father.
Otherwise, suppose a scheduled caste man
Yes.
adopts a Brahmin, a rich Brahmin.
He is not a rich, that is not there.
No,
he is not
I'm
a,
just giving an extreme
yes,
example.
yeah, for example.
In Tarka Shastra, the extreme examples are given to throw light on the issue
Yes,
and to arrive at a logical conclusion. I'm just saying,
yes.
we have 4 varnas which have become jatis, although Lord Krishna said,
Now it has become many.
yes, I mean, this is one thing. Lord Krishna said, Chaturu Varna Maya Srishti,
Yes.
Guna Karma Vibhaga Shaha. But that is not true now. It is not based upon Varna and your property, your nature. It is by birth. Is it not? If that is so, if adoption were to be, because in one judgment apex court said, by marriage you cannot become member of that caste.
By marriage you will not be.
But by adoption also. Otherwise, the very policy of reservation can be defeated. If everybody goes for adoption, saying that I will bribe to take my child as a scheduled caste man. Very policy can be. It's just a huge potential.
That judgment I have seen that.
Yeah.
But here, my lords, he has been adopted from the childhood. And he has, in the meantime, passed MBBS. And now they say that the MBBS certificate is to be cancelled. And continuing post-graduation. And the reports collected.
Because in Melinda
case I have seen me.
that is overruled now.
Yes.
If Melinda were to be there, perhaps I would have permitted you. Otherwise, because apex court said in latest judgment, 2023 or 24, I don't remember. If it is, of course, it was a case of fraud. But here it is not a case of fraud.
Here
who appears for the respondent?
Here the DSP report also supports.
Support. What is the support?
You also may kindly see the DSP report.
Has it been brought up in the environment of a scheduled caste?
Yes, that is the entire evidence. And the evidence collected I have.
And the community treats him as the son of a scheduled caste man.
Communists have treated him as a son of scheduled caste.
Oh, which is that judgment? Madhuri Patil versus
Yes, Madhuri Patil I have read also. I have got Madhuri Patil.
Give that. Take another judgment, Laviti Giri versus Andhra Pradesh, etc., etc. This issue is decided now. Under adoptive father, adoptive children, I do not think. Which paragraph, Madhuri Patil, how to decide a caste of a person? Which paragraph?
Here, mirrors. There he was continuing, so they allowed him to continue. Ultimately, para 13 at page, just say the Para 6, your lordship may kindly see.
Para 1.3, read 1.3.
Yes, I've seen that one. I was just going beyond that. Yes, Lord. Admissions wrongly gained. That I was saying. Appointment wrongly obtained on the basis of false social certificate necessarily has the effect of depriving genuine scheduled caste and scheduled tribes and OBC candidates as enjoined in the Constitution of the benefits conferred on them by educational institution appointments to the post of the state for want of social status certificate. The ineligible spurious persons who falsely gained entry resort to dilatory practice and certificate hurdles completion of inquiry by the scrutiny committee. It is true that the application for admission to social institutions are generally made by a parent, since on that date many times the student may be a minor.
This one, the rest of the things are this one.
Yes, that is the thing.
Then any decision on adoption?
I'll check it.
You will check that.
Your lordship may kindly see page 96.
Go to 96.
96, last.
Of judgment?
No.
Yes, my lord. The final order of the state level scrutiny committee, my lord.
Good. 96.
Yes, 96 of the writ petition.
94, this is the Madhuri party only.
Yes, Annex 9, my lord. Annex 9.
Duly consider the investigating officer's report and other
The state level scrutiny committee duly considered the investigation officer report and other relevant record and observed the follows. It is revealed from the report of the investigation officer that the alleged Sri Tanmoy Kumar Meher, village Viranor Singhpur, post Both district, is the natural born son of Kaushik Meher of the village Vakapalli of Harbanga block in the district of Bodh. He is a Bhulia by caste.
I have said that.
Coming under OBC, SCBC category. One Pratap Chandra Meher, son of Hari Meher.
the adoptive father is Kulis.
Yes, Kulis by caste.
Kulis by ST category.
He is ST category and his
son was aged what at that time? This adoption took place on which day?
4 years. Evidence says 4 to 5 years.
No, he was studied up to 5th standard.
No, when the document was registered.
when he studied at 5th standard, his father name was changed.
Up to 5th standard. The
6th standard, at that time 6th standard.
6th standard,
yes.
6th standard means in your state admission to 1st standard takes place at what age?
About 5 plus.
5 plus.
5 plus.
So he will be 11-year-old.
No, 9 years old, then 9 years old.
How? 5th standard he was, at least 10 years he will be. If it is 5 plus, it has to be 10 plus.
No, not always that. Not always boys pass in that age. I saw the.
So if he was a small child, a baby, suppose a breastfeeding.
No, it is not a breastfeeding.
I can understand.
It is not breastfeeding. Why should I better know? If you also see that next para, it is removed from the investigating report that both the natural and adoptive father alleged as well as villagers have admitted before the IO that Tanmoy Meher is the naturally born son of Kaushik Meher, who is Bhulia by caste, and adopted by Pratap Meher, who is Kulis by caste. That is their investigation report. That report I have annexed also.
No, we don't deny anything.
While submitting the so-called reply, he agreed that the actual facts of finding of the inquiry that he is the natural son of Kaushik Meher, who is Bhulia by caste and was adopted by Pratap Chandra Meher, who is Kulis by caste. I have also annexed all the evidences collected by them.
A tough question. No decision on this? No decision of any high court in the country?
There are some.
Your lordship may kindly see the last para. Further, the government in SC/ST Development Department Odisha Bhubaneswar clarified in para 7, 6 of the letter number such and such dated 22/1/2008 read as follows. A person can claim to be from the scheduled caste or scheduled tribe by birth alone. In Mrs. Bhalsama Pal versus Cochin University and others, AR 96.
Because the matter relating to marriage it was. Bhalsama Pal was a matter of marriage. It was not adoption. Bhalsama Pal case, in fact, it is an aberration. It said because she married into the particular community and the community accepted her as a member of that community. Therefore, Supreme Court said, Honorable Supreme Court said, that she can be treated as this one. In other cases, Bhalsama said, other paragraphs, the caste is always by birth. Therefore, I quoted it from
Mahabharata. I don't dispute that. But here also, in our state also, others are adopted in different caste. Not
give me some time. I just read. I will also.
Your Lordship, let notice go.
Let's notice.
Let notice.
Issue emergent notice. Any interim order you have sought?
Yes, I have sought for to allow him to continue the post-graduation. He has already continuing post-graduation. Your Lordship, no doctors, 1 year he has completed. Shortage of doctors. Suppose he becomes a doctor. Suppose he loses his caste also. Can the qualification go?
No, that question is answered in a judgment which overrules Milinda. In Milinda, that was the consideration.
I've seen.
But Milinda is no longer good law now.
Yes.
Milinda is watered down by the subsequent.
The whole difficulty is continuing. Let him continue, then if after your decision is taken, that is my only prayer.
Learned senior advocate appearing for the petitioner submits that his client, having already graduated in medical science, is now in the PG course halfway through, and he should be permitted to continue so that the resources, the public resources used for education of this person may not go waste. And in any event, the petitioner shall not plead equity when the matter is taken up for a final hearing. First time. Do you agree, sir? In the event we are going to allow and put a condition that you should serve for 5 years in a scheduled tribe area?
Yes, I am willing. 10 years, Your Lordship, I am willing. I am a scheduled tribe, so area, no problem, difficulty about that. To be in scheduled
you were in writing. Ask your counsel on writing.
Memo. I am willing to work in a scheduled tribe area for 5 years. Within 10 minutes, I am filing that.
Yeah.
Once undertaking, it is not
on the instruction of the counsel on record, that senior advocate submits that his client will be ready and willing to work in as a doctor in the scheduled tribe area in the event he succeeds in the petition. And to that effect, he has also filed a memo which reads as an you will produce that. Okay, first one. Next one, considering the equities involved and balancing the same, it is desirable that the petitioner be permitted to prosecute the courts in question, and that shall be subject to. He is not pleading any equity as mentioned above. First one, petitioner be permitted to continue and accomplish the courts in question.
In that event, Annexure 9 be stayed.
Just to outcome of the writ petition. First, as a corollary, impugned
Annexure 9.
Annexure A
9.
Annexure A
9 and 10.
Annexures 9 and 10 are kept under suspended deliberation. Okay.
Section 47.
May I please?
No, sir, no decision of any high court in the country.
There is one decision. That is one high court decision.
Just give that judgment. Court officer, give that judgment on my table.
Yes, sir. Yes.
In this case, I will file counter.
Okay, counter.
Last.
Not
Last.
admitted.
Last
Admission is yet to happen.
No, not this, but last.
In that matter, na?
Yes.
Counter there.
The opposite parties to file counter within 6 weeks. 6 weeks.
Yes.
Yes, sir.
Well, the dispute is relating to appointment of principal in charge of a lead government college.
Principal in charge.
Principal in charge. Your Lordship, I kindly turn to Annexure 7 at page 52. The opposite party number 3, who is admittedly junior to me and who has not acquired PhD qualification. I am an associate professor and he is also an associate professor.
Requirement for the post is what?
Requirement for the post of associate professor is one must have acquired PhD degree as per the UGC regulation. And so far as the state rules, Article 309 rules is concerned, for the post of professor, which is equivalent post to that of a principal, PhD is a must. He has not yet acquired PhD degree. Since there is no professor in that college, the senior most associate professor is to be kept or appointed as principal in charge of that college. Your Lordship, I kindly see the regulation, UGC regulation that I have given under Annexure 5.
Yes.
That is 2018 regulation. It starts from page 34. My Lord, may kindly come to page 36. UGC regulation is mandatory for all.
It is only an in charge basis.
But I'm coming to that. So far as his qualification is concerned, even he is not eligible for the post of associate professor. But he has been promoted to the rank of associate professor.
Take out Basavaraj Dhotrad. Take out that decision.
My Lord, I have also brought a Supreme Court judgment where the statute does not provide any rules or provision for determining inter-se seniority. Length of service is the golden principle.
For in-charge arrangement also?
Yes. Yes.
Supreme Court said, 91
yes.
Supreme Court.
Yes.
Take out Basavaraj Dhotrad versus the managing director.
Your Lordship, I kindly see this judgment.
Okay.
This is the latest, 2023. My Lord, may kindly come to page paragraph 22. The flag mark portion. A 3 judges bench of this court in Chandravati, PK and others 29 referred to a number of earlier judgments on the issue, including D. Stephens Joseph, Satpal Antil versus Union of India, Anil Kumar Gupta, A.K. Raghumani Singh versus Gopal Chandra Nath and Pramod Kumar Pankaj versus State of Bihar, and quoted with approval of the last.
It's a different view.
So here
narrative. This very point is decided by the apex court in ILR in AR 1991 Supreme Court.
Yes. I'm conscious of that.
Supreme Court.
The golden principle is length of service. Golden principle is length of service. Where statute does not provide any.
No, not that. This is quoted in one Karnataka judgment, I remember.
Yes.
Brother, anybody in the court? Basavaraj Dhotrad versus managing director, Justice Nazir's judgment, which quotes rule, because I had argued, I remember that.
Yes.
I had argued that matter.
But here I am challenging on 2 grounds.
1 second. The very point is considered, very point I had argued the matter. Can you get one then?
Yes.
ILR 2004, 5, 6. 4 may not. 6 maybe. The Honorable Justice Nazir's judgment. Can anybody take out? Basavaraj Dhotrad versus so and so. There the Honorable Judge, and it is affirmed by the division bench.
Yes.
There they quoted Justice Ramajoy's book. If anybody can get that judgment, we can services under the state, where he says seniority and such other things are not a consideration while placing a man in independent in charge basis. For independent charge, yes, what you say is true. For in charge basis, there is nothing.
This is independent charge.
Huh?
This is independent charge. Your Lordship, may kindly see the impugned order. Annexure 7 at page 52.
Just look into that judgment that is
yes,
against you. Then you may argue. Because this suspect is considered by the apex court.
Let it come tomorrow.
Well, tomorrow. Bring that judgment also.
Yes.
I don't have a research facility here.
Yes.
We don't have regular researchers in this court. Yeah.
My lord, representation is pending.
No.
That will not help. We will reject
that. Will not
that we have done it properly.
That will not help.
Yes.
Item 48.
May I please? Here the petitioner is a retired reader. He has questioned the annexure 5 and 4.
Reader means he has stopped reading.
Yes. Now, he has questioned the impugned order under annexure 4 and 5, where the gratuity has been reduced from 7 lakhs to 5 lakhs. That is the impugned. Initially, under annexure 3, that was enhanced to 7.5 lakhs. And for a particular period, again that was reduced to 5 lakhs. Again, subsequently, that was enhanced. So for a particular period from 17 to 24, the persons who took retire, even if they are senior, now they are getting 5 lakhs. That is the issue.
Any judgment on that? The power to do it is there.
The power to do, they have amended the rules, but the rule is, my lord, that must be reasonable. A person, even if junior, now he is getting 7 lakhs. The person who is senior, he is getting 7 lakhs. But in between these 5 years, my lords, that the person who retired in between, now they are getting 5 lakhs.
That happens, brother. It happens. It all depends upon, it's more a matter of economics, finance.
Economics, but that must be reasonable, even if economics. Your lordship is supposing that right. But what is the reasonable excess?
That must be size of the purse. Size of the purse. This side dictates the policies of the government.
The policy must be reasonable, your lordship, that's right. I cannot say no. But that must be reasonable, your lordship. Visualize what is the reasonable excess. Let them say what is the reason. That must, your lordship can scrutinize whether the region, what is the nexus between this. And even a person they retired today, he will get more gratuity. And even if I was senior, I will get less gratuity. That is the matters.
Who are the respondents?
The government lords. This is the first time coming.
Issue emergency notice. The NET-EGA is requested to accept notice for the
1 and 2
respondents.
AC, my lord.
ASC. AC. Right now. Yes.
All the 3 matters same.
Same. Call along with each other.
Item 49.
You are the petitioner, my lord. You are working as a lecturer in an aided institution, my lord. It's challenging Annexure 3 issued by the principal of the college, whereby the principal of the college, without following any procedure as contemplated under law, without giving any show cause, straight away, my lord, directed to terminate the service with effect from 31st. That is under challenge.
No, what was it tenure service?
Tenure, contractual.
What about it?
But the institution is an aided institution, and the Act, Odisha Education Act, Section 10A, specifically provides that no teachers of an aided education institution shall be terminated without approval of the prior approval of the director, concerned director.
But that applies only to the regular teacher.
Institution. Yes. That is the language, my lord. That is the language also kindly see.
No, the other word teacher is defined.
No, teacher is not defined. Only institution. The Act prescribes teacher of an aided institution shall not be terminated without prior approval of the director.
Correct, you said that.
Yes.
But question is whether that section applies to contract teachers also.
Yes, because there is no distinction between contractual teacher and regular teacher.
There is.
In the present case, institution, there is an institution receiving grantinate from the government.
Where is your appointment order?
Appointment order. Annexure 1. Annexure
2 series, page 17. I'm challenging that letter annexure 3 on 3 grounds. First is non-compliance of section 10A Act. Second, violation of principle of natural justice. Even no show cause has been issued before issuing annexure 3. And thereafter, without jurisdiction. Because now the governing body under the rule, governing body is the appointing authority. Please to appoint me, kindly see annexure page 17. I have been appointed as per the decision of the governing body, resolution number 29, dated 8/2/24. But now, while straight away the principal in charge, in absence of governing body, he has passed the annexure 3 to terminate the service.
Issue emergent notice, stay of impugned order. First off, this interim protection is granted in view of assertions of counsel for the petitioner that that in the absence of governing body's resolution, the author of the impugned order would not have made the said order in his official capacity. First time.
There's 5 cases, my lord. Today, before you also only 4 matter listed.
So you will bring some more matters tomorrow?
No, 1 matter left, my lord. I have mentioned all the matters. Okay. Today come only 4 matters. Only 1 matter, that is WPC number 21204. Same institution, same annexure.
Let it come tomorrow.
Tomorrow. I have given the number to CORAM.
The serial number?
Serial number 49. All 4 matters same.
Okay. Yes, brother, whether what is the law? Whether contractual appointments are also covered by that rule? Just look into it and say.
I'll check it out.
Requested WhatsApp notice, sir, copies for the official respondents. Copies? Yes. With your terminology, I meant to become close. I'm learning that. Yes. Yes.
Item 50.
Here, the issue is a short grievance of the petitioner. He is entitled for 1 increment, which is due just 1 day after his retirement. Now the issue has been settled by the Honorable Apex Court while confirming the judgment of the Honorable Karnataka High Court. That I have enclosed. And our High Court also decided 1 issue. But till then, I have not been extended. And except
the representation.
Representation I have moved.
Let them consider the representation in the light of the judgment.
Judgment annexure 3 and 4. 4 is the Supreme Court judgment, whereby the Karnataka High Court judgment has been upheld and the very issue has been decided.
Where is that representation?
Representation annexure 6, madam.
The short grievance of the petitioner is as to non-extension of, non-granting of a particular increment, presumably because he retired soon thereafter. First, learned counsel for the petitioner submits that seeking grant of increment, his client has already made a representation dated 7/4/2024.
So actually 25, the type mistake 24 has been mentioned.
Yeah, just don't say.
25.
Give that file to me, just rectify. 7/4/2025. A copy whereof awaits and annexure 6. And the authorities are bound to consider the same. First off, he also draws attention of the court to a coordinate bench decision of its court reported in 2021, volume 2, OLR 529.
Upheld by the that has been upheld by the writ appellate court also. Page 30. Writ appeal number 117 of 2022. That very
it is said to have been affirmed by the division bench in writ appeal number 117 of 2022. First off, he also has mentioned Apex Court decision in the director KPTCL versus CP Mundinamani 2023 live law SC 29. First off, learned counsel argues that despite the entire material being available, no decision is being taken on the subject representation, and therefore the authority should be mandamus to take one first. Next paragraph. Learned AGA, on request appearing for the respondents, opposed the petition, contending that grant of increments of the kind is not automatic. Several conditions to obtain normatively, unless those conditions are complied with, no relief can be granted to the employee of the kind. First, having so argued, he agrees to instruct his client to look into the grievance of the petitioner, as has been aired in the subject representation, in a time-bound way, if all contentions are kept open. First, this is a happy thing to happen in adjudicatory process. First, next, in the above circumstances, petition is disposed of, prescribing a period of 8 weeks for taking a decision on the subject representation, and also to inform result of such consideration to the petitioner here. First, next last paragraph, it is open to solicit necessary information. Print. Now first.
Item 61.
Yes.
Well, the petitions are continuing since 22/2003 as a M.S.SAHOO, but till yet not regularized in service. Despite the recommendation, I annex 7 mile page 45. So,
This is mandamus for
regulation.
where is the representation? Have you made the representation? Seeking you regularize my services.
Not earlier they approached along with the other smiler. And pursuant to the order by the annex, earlier page 39 might have a glance.
Page 39
were there. Page 39 mile.
Page 39.
Mile.
Annexure 5.
Mile.
Now what happened in that?
On page 42 mile. For regulation of the claim and pursuant to the order of this, they are continuing till 8 mile. And the said petition and dispose of as in no instruction. Although some of the petition were regularized during pendency of the petition mile. That's why
no regulation is granted to you.
But we haven't discussed. We have not granted. Now they are taking steps since the petition is disposed of and taking steps to disengagement.
Yes, brother, what do you say? If you have regularized services of a set of people, you cannot discriminate unless you have followed some normative procedure. Seniority, availability of posts, reservation, this, that, etc.
Take instruction.
Come back.
Take instruction.
But don't disengage them till next date of hearing.
Yes.
Issue emergent notice. Interim direction to continue the services of petitioners till next date of hearing. First, this interim protection is granted on the assertion of counsel for the petitioner that similarly circumstanced contract employees have been continued and a stepmotherly attitude is shown to his clients. First, matter needs deeper examination. Okay.
52.
This is an application for amendment.
Application is amendment.
Yes.
What amendment you want to?
There was some mistake on my part in the petition. The prayer portion, I have not incorporated something. So I have challenged the entire order, but only a part is required to be challenged by me. This is case for regulation, the formal.
Brother, we will follow the application. Notice is not it.
No, not it is. Before that,
to amend that. An application supported by an affidavit is moved seeking a little modification in the prayer column of the petition. That too by way of restricting the challenge to particular orders. First, matter is not yet, no notice is ordered in the matter as yet, and therefore there should be no impediment, legal or factual, for permitting the application, allowing the application, granting leave to amend the cost prayer column as sought for in the application. First, leave is granted, permit
By tomorrow,
the petition to be amended. First,
Consolidated petition by tomorrow, I'll file. That is
amended petition to be filed within 1 week.
by tomorrow, because it has
We
to be
have given
admitted.
1 week. We have given.
It has to be come for admission, my lord. There is urgency. That is, I undertake, my lord, I'll file by tomorrow.
First, immediately after amendment is effected.
Fine. Okay.
53.
May I please, Your Lordship?
Yes.
No, this is a case where, notwithstanding an agreement before this honorable court, now, my lords, the government is backing out for allotment of land to me, my lords. Let me explain the facts of the case, my lords. After the recommendations of all departments, the government in principle, there's a land committee, my lords. In principle, they agreed that a land will be allotted to me for a hotel. Now, my lords, that is at annexure, that is 32. It's a part of annexure 1. Your lordships may kindly see.
The objections are, this is coming after notice.
This is after notice, my lords.
Objections are filed by the
Yes, my lords. Pleadings are complete.
Who appears for the response?
ITCO.
I appear for the ITCO. Our response is that the provisional allotment had been given, but subsequently, because the ITCO does not have its own land, it gets the land from the government. Revenue Disaster Management Department, they give the land on acquiring. We give the cost and then we get, then making the industrial infrastructure, we allot for the industry purpose. So in the meanwhile, what happened, that no doubt what he says, the district single window clearance authority, that means a committee, recommended provisional allotment was given. But subsequently, Revenue and Disaster Management said that these are the social infrastructure for hotel purpose and tourism related. So that will be given only through auction. So it cannot be given throwaway like this. So that is why the Chief Secretary Committee, they decided this, and accordingly that was cancelled. After that,
provisional allotment was made in which year?
2010, my lords. Let me place the facts, my lords. What my lord? Yes, sir. I'm sorry.
I have handled similar matters.
My lord?
I have handled hundreds of similar matters.
My lord.
Therefore, I'm
2010, provisional allotment.
full date.
18/11/2010.
Who made this allotment?
My lords, ITCO itself.
What is the legal status of ITCO?
ITCO is Orissa Industrial Infrastructure Development Corporation.
it is under
It's
the
a government of Orissa. It's a statutory body, my lords.
Give the give a brief sketch of the thumbnail sketch of the act.
Act, my lords. It's basically act. I haven't got the act, my lords. I'll get the act.
My submission is this much.
Without act, you can't make submission. Have you brought your act? He has not brought act. You have not brought act. And you want to argue on legal principles.
ITCO Act.
Do not waste time on this matter. On 24/8/24, no, it has to be 21st. I will put this matter.
Yes,
21st August.
21st August. Your lordship wants the ITCO Act.
Yes.
Yes,
So how the act functions?
Yes,
my lord. Certainly, my lord.
State legislation.
Yes, ma'am.
I want to know what
Yes,
is what.
Yes, ma'am.
Bring all acts,
Ma'am.
bring all rulings, and work out possible questions of the court by your wisdom, experience, standing, and come with preparation.
Madam.
Yes.
Item
Obliged.
54.
In this case, I have started actually 11, Your Lordship.
11.
Yes, Your Lordship.
Objections are filed.
No, Your Lordship.
No objections filed.
No, Your Lordship. It's a matter 2019, Your Lordship. It's a matter 2019. The state has not filed the objection yet.
Matter.
Yes, Your Lordship.
What is your grievance? Tell me in 3 sentences, small sentences.
I have applied for the post of Sikkha Sahayak under the PWD category.
You have applied for?
For the post of Sikkha Sahayak
Yes, I.
under the PWD category. Now, as per the benchmark disability, I need to have 40% disability, either temporary or permanent. They verified. My name found in the merit list. I was recommended to appellate medical board. They verified me. They stated that I have 40% temporary disability. Now, pursuant to that, they didn't give me the order of appointment. Challenging that, I have come to this honorable court. This honorable court directed the collector to take decision. He didn't take so. Subsequently, I made a complaint before the commissioner.
Disability.
Yes, Your Lordship. They recommended my case, stating that you should consider his case because the RPWD Act doesn't discriminate between the temporary or permanent disability. Now, basing on that report, I again up to this honorable court. This honorable court.
Yours is a temporary disability.
Yes, Your Lordship.
What is that disability?
Low vision, so LV and HI. The multiple petitions are there, Your Lordship. You also will find the page 51, Annex 5, the extent of my disability.
What is the extent? Prescribed extent is 40%.
Yes,
minimum.
Your Lordship. I have 40%.
40%.
My lords.
How long? This temporary means how long it will last?
That is not stated there, Your
Not
Lordship.
stated.
But the commissioner, he recommended my case, stating that you cannot discriminate between temporary and permanent.
That appears to be doubtful.
At Annexure 10, Your Lordship, page 76.
Suppose the disability is only for 3 months. Afterwards, it goes. Can you get appointment on the ground of temporary disability and remain in the post even after losing that disability?
Answering Your Lordship's query, Your Lordship, can see page 63. It is a resolution of the state, page 63, Your Lordship. It's a corrigendum issued by the Social Security and Empowerment of Persons with Disabilities Department.
Corrigendum 2?
To the resolution, Your Lordship.
Resolution is
Yes.
issued under which section? Which type?
My lords.
Resolution is made under which statute?
Section 34, Your Lordship.
Of the Act,
Yes,
PWD Act.
my lords.
New section of PWD. Persons with disability. Whether its nomenclature has undergone change.
My
New
lord.
Act has come into force now.
Yes, this is an amendment, Your Lordship, but it's prior to that.
16.
Do you have read that section?
My lords. Section 34. Reservation. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clauses A, B, and C, and 1% for persons with benchmark disabilities under clause A, D, and E. If I handle the
So it
book,
provide for reservation.
my lords.
Pursuant to that, this resolution is.
Yes, Your Lordship.
What resolution says?
The resolution says,
Not
Annexure,
less than 40% is courage act.
my lords. The 63 Annexure 7, Your Lordship. Should I read it, Your Lordship? Persons with not less than 40% of any disability.
I read that.
I'm sorry.
So you are saying 40%.
Yes, Your Lordship.
Then you say it cannot be the person's PWDs cannot be classified on the ground of the disability is temporary or it is permanent.
My lords.
So what
On the
is meant
basis
by
of
temporary, I want to know.
my lords.
Suppose if the disability endures for 1 week, for them also the appointment to be given. Going by your version.
After going through, even I have the doubt, Your Lordship, but after going through the resolutions and the commissioner's order passed in my favor, what I've understood is that I was initially issued with the disability certificate of permanent nature.
On this, various high courts have said what?
My lords.
Where 25 high courts in the country.
Yes, Your Lordship.
How they have viewed this question?
That I have to verify.
That you have to make research and come back.
My lords.
It is not that for the first time.
But
This court is this question is
my
arising.
lords. My lords.
Maybe that it has arisen before very many courts already. Take this. Or in the second week of August 2020. Second week, bring all the judgments of the various
My
high
lords.
courts.
My lords.
There is one judgment of our High Court also. I do not exactly remember whether it went on that line or etc.
If it can be seen from another angle, Your Lordship, once the commissioner makes a recommendation.
No, what we will not do. It's a recommendation.
Section
It's not
18
binding.
says the appropriate government has to take a decision on it on the basis of the recommendation made. But the instant case, Your Lordship,
They have not taken.
yes, Your Lordship. But another angle is
If we direct them to take a decision, will you be happy?
they've already rejected without giving
They have
reasons.
rejected.
Without giving
That
reasons.
temporary are not covered.
They're not there. That is silent. They're silent about that. That is the issue. He's not speaking
But
about it.
anyway, even according to you, your clients have only temporary disability.
My lords.
Madam, for whom you appear?
No, I am appearing for OP number 2. He is challenging the order passed by the government.
Government. You
I am
recommended that.
recommending.
They recommend in my favor.
I'm also not good in PWD matters because I have not handled these matters.
I'll try to assist Your Lordship.
Just I will also read and come back.
My lords.
Item 55.
Yes.
Yes.
For the petitioner, my lord, but I filed the rejoinder in this matter. I humbly.
Your voice and case both are weak.
Sorry, man. My lord, I have filed the rejoinder. I humbly pray for some time, my lord. My lord may fix up
the request now.
Item 56.
Yes, sir. My lord, here the notice was issued since November 2022. Matter relating to
Anyone is left out?
state is the opposite party.
See what help we need. Senior gentleman wants some help. Yes, sir.
Petitioner before your lordship is a retired or an average personnel. And he was found selected in the lottery as per the government's procedure to be allotted with a plot. But at the very beginning, I must say that since that is in Oriya, I will have to put vernacular to that. And at the same time, I must pray your lordship to have a glance to the order dated 23/11/2022 by which this honorable court directed for filing of counter. Notice was issued.
No, not
No, my lord.
Government.
Government 1, 2, 3 is government. 4 has notice has been issued. Nobody appeared.
Respond 4. Who is the respondent number 4?
Respondent number 4 is Rajya Sainik Board, Nageshwar Tangi, Luis Road, Bhubaneswar.
Rajya Sainik Board.
Sainik Sangh.
Sainik Sangh. The notice is sent to them already.
Yes, my lord.
One fresh notice.
My lord, what I say that from the nature of dispute as it appears that opposite party has no role. We have made a performer party. What the role is, vital role is of the government. Because government.
What do you say, Mr. Yes,
Not file and counter.
You want to file the counter?
Yes, sir.
But the way government lawyers, most of government lawyers do not file objection at all. Next time we will do, if objections are not filed, we take the petition as true and correct and grant relief to them. Then you will wake up. filing review petition, etc., making a submission before the division bench saying that no opportunity was given to file the objections. How many years the litigant should wait? 20 matters, 22 matters.
22 matters.
While Mr. Mohanty, in most of the government matters, objections are not filed. 22 matters. Something has to be done. Otherwise, we will take the petition. No less value.
We'll take care of, because in the passage of time and changing of the, we'll take
2 weeks for filing objections, if any. Failing which right to file one stands forfeited. Your rules say only 2 weeks. I examine. For filing of objections, 2 weeks. With permission of the court, 4 weeks. Yes.
57.
57.
You're not allowed 2 weeks time.
It's 2 weeks time.
My lord, no, my lord, not my case, my lord. My pension has not been paid, although I have retired on attending the age of superannuation in 2023 May. 2023 May, the notice was issued on 6/5/24. Adjourned date, nothing has been filed, and I am suffering.
I am in this case, I am for the university. That is the state-run university. State runs university. The finance which comes from the state. So state government is necessary party. But here is a case, my lord, he has filed an annexure, my lord. Annexure 7, that recommendation. That also is.
That you will reject and again you will make her to suffer.
Yes.
So that will file the counter, my lord, 2 weeks, file the counter.
2 weeks. Yes. 1 week we will give you. Next week you have to tell. You can't harass the retirees.
Yes, my lord. But one thing, my lord.
How many years of service you have put in?
My lord?
How many years of service you were
33 years.
43 years. 33 years. Why, brother?
The state, here the state government is necessary party.
No, state government is not necessary.
You sell your library, part of the library, and give the pension. Or you sell your table, chair, etc. and pay the pension.
2 weeks time to file counter.
1 week I will give you.
Yes, ma'am.
A retired employee having put in about 33 years of service, spotless service, he is grieving before the Red Court that even today his terminal benefits have not been granted. First up, notice was issued by the coordinated bench wide order dated 6/5/2024, and till this day the university has not bothered to file its statement of objections. First up. However, as a last chance, the university is granted a period of 2 weeks to file the objections, subject to paying a sum of rupees 10,000 to the petitioner.
No, my lord, recently the 2 sorry, my lord,
You challenge this
24, my lord. It's the matter of 24 we have.
How? It's a pensioner. It is not some other under your rules.
Yes,
within 2 weeks, you have to file this statement of objections. Pay 10,000 rupees. This amount may be recovered from the officials responsible for.
It is also a problem for me. Also, my lord. 3 days time. Within 3 days, I file counter, my lord.
Till date, you have not filed. For that, I have imposed them. Otherwise, the university will not. Universities are sleeping now. I know that. Yes.
Your my lord, date will be fixed.
Within subject with full stop. Call this matter on the date caller after 2 weeks. Some date. Give some date.
My lord, in 2 weeks, I filed the counter.
You filed, we will give you. But 10,000 rupees. It cannot be free.
There is a problem for my lord.
For you, it will be problem only.
Yes, sir.
It's about the problem of the employee.
Yes, my lord. It is a contractual employee. He is not regular in the beginning of my lord.
Have you filed your counter?
My lord.
Have you filed your counter? Therefore, we are
I am ready for file of counter for 3 days. My lord, grant me only.
But you now wait 3 days.
Only 3 days. My lord, file.
Then also 10,000 rupees.
Problem.
Because till what 10,000 rupees is for not filing the statement of objections till date.
No.
Not for giving permission to file one.
Yes,
It is free.
Yes, my lord.
Or you want for that also to be levied?
Sorry, my lord.
13 August 13.
My lord, it is a problem for us. So that
Everybody, it will be problem to everybody. Court orders are problem.
Yes, my lord. Sorry, my lord. I argue this matter, my lord. I argue this matter. Otherwise, the lordship is a consensual appointment. It's beginning.
Where is not, where are you? We can't make oral submission like that. The pleading should be there. To say nature of appointment, nature of employment.
You lordship cost to me.
He has worked. He has worked.
If your lordship cost to me to the university, so it is also a problem to me.
It is always a problem. Court orders are problematic only. The courts are not for playing love game. They are there to impose. They are there to imprison. They are there to
you go to
take away the property.
You lordship go to order street. That is the first time it is listing.
Why it should be listed? For you filing the objection statement. Why it should be listed? You can file it in
the order street. Your lordship kindly go to the order street. Further we have cost. Further your lordship, if your lordship not file in 3 days, I have paid the cost, my lord.
We have made the order. Next matter.
Item 58.
My lord, 5,000 so that I take my
5,000. Take it. Yes.
May I please, my lord? My lord, petitioners are teaching and non-teaching staff of a high school.
Hereafter, you see how universities will file their objections in all matters. They may file advance objections also.
Yes, my lord. But my lord, I pray one thing.
You have prayed, we have given you 5,000. If you argue more, it will be 10 again. Yes.
Petitioners are teaching and non-teaching staff of high school, claiming grantinate by filing a grantinate case before the Law and Tribunal under Section 24B of the Orissa Education Act. Two of the employees, they also separately filed a separate grantinate case before the tribunal, claiming same benefit of the same institution. Their grantinate case was disposed of, and against that judgment, state government filed an appeal before this honorable court that was dismissed. Thereafter, matter was went to Supreme Court dismissed, and benefit was extended to those 2 persons. Subsequently, our judgment was pronounced by the tribunal in our case. Against our judgment, they filed a affair before this honorable court that was dismissed, but benefit was not extended. They rather, instead of filing SLP before the honorable appeals court against the order of affair of the honorable single judge, they filed a writ appeal before the division bench. That has been dismissed. Since that benefit has not been extended and other benefit has been extended in favor of 2 persons, I approach this honorable court. And in pursuance to the order, my lord, kindly see 3rd of September 2024, they have already released the current salary. Order dated 3rd of September 2024, my lord, kindly see. And they prayed to release the arrear salary within 30 days. And they have to come.
They have paid now.
They have not, only they have released the current salary in pursuant to order dated 3rd of September. And they prayed 30 days time to release the arrear. In spite of that, they are not doing it.
Where is that 30 days?
3924 order, kindly see.
Yeah, there are
last 2 lines.
You can arrear salary is due and dismissal will be released within a period of 30 days. Hence. Yes, sir, you wanted to. I will direct arrest and detention of your officer. Who is the officer?
My lords, I question the maintainability, my lords.
That's all right. There is an order now. Rightly or wrongly.
My lords, that order was. The first order was carried on in appeal, my lords. The appeal was dismissed in the month of June.
Now we are end of July.
July, my lords. Now I have to take instruction whether they are going to apex court or
not. I do not know. As long as the order remains. If there is order says jump,
my lords, another thing, to jump. My lords, there is alternative remedy, my lords. They have filed execution case.
This is an undertaking given to the court. Kindly see that. This is an undertaking given to. I will direct arrest and detention of
my lords, this matter, this writ petition or execution of order passed in FAO. My lords, that FAO against that order, government carried appeal, my lords, before the
appeal dismissed.
That was dismissed in
June,
30th June, my lords. Just recently. I am
now 30th July.
July, my lords.
And you don't want to do anything?
No, my lords. Now, government They may take a decision whether
Government will take
they
a
may-
decision for direct arrest and detention.
they may challenge in apex court.
Where is the stay? You should have run to Delhi with the order. 30 days are over and the order was made on 3/9/2024. I will call this
My
matter
lords, the writ appeal was
on
dictated
36, sir.
My lords,
That's right.
36th June.
Once it is dismissed, you mean to say till a period of limitation for approaching the court of the Supreme Court is over, you should not enforce the order?
No, my lords, I am not.
That becomes the-
No, my lords, I am not submitting that. My prayer is that government may take a decision to challenge that order. That opportunity should have been given to us.
How many-
That period,
30 days are over now.
some time may be given, my lords. 15 days time.
Question is, you can't take time because you have undertaken to make the payment.
My lords,
Therefore, writ appeal is this. Having undertaken to pay the money to this court, and if you do not abide by the undertaking, what kind of government it is?
my lords, before.
It is not an order. It recorded your undertaking.
My lords, that undertaking, my lords, that was challenged in writ appeal.
No, undertaking cannot be challenged.
My lords, that order, my lords,
it is dismissed.
my lords, this is for execution of an order of tribunal.
Brother,
My lords,
why can't you understand law of elementary knowledge? Should not you have about the contempt of court? Elementary, any standard book will say
My lords,
where undertaking is given to the court can enforce the undertaking. Kindly see your undertaking,
My lord-
your brother's undertaking.
my lords, that undertaking has merged in writ appeal order, my lord. Now, I pray to
No.
2 weeks time.
Undertaking does not merge. Orders may merge. Undertaking will not merge.
My lords, I will take instruction. I'll see that it is.
Call this matter tomorrow.
Tomorrow, my lords, it
Why?
will.
No. As to why the order dated 3/9/2024 of this court, the coordinate bench order dated 3/9/2024 has not been complied with, despite challenge to the same in writ appeal having been negatived by the division bench on 13 June 2025.
23rd June. 23rd June.
23 June.
23rd.
My-
3/6/2020.
My lords, may I pray little prayer?
Yes.
My lords, grant 7 days time. It may not be required, my lord. It may be solved, my lord. 7 days.
Call this matter on 7th for reporting compliance of the undertaking.
Man.
7 days will be when it will be. Monday? Tuesday. Tuesday. Call this matter for reporting compliance of the order dated 3/9/2024, which at paragraph 4 records the undertaking to make to release the arrears of salary within 30 days. Within 30 days. Okay. I have come out. The said period having lapsed long ago.
My lords, put it to 7th, my lord.
7.
Item 59.
Yes.
Brother, the concerned officials are put to warning that non-compliance may lead to penal action, which may include arrest and detention.
My lords, may grant me a copy, free copy,
Yeah.
so that I can communicate.
For the registry to share a carbon copy of this order with the learned AG immediately. Yeah.
Item 59.
Yes. May I please, Your Lords?
Yes.
But the petitioner, pursuant to the advertisement under Annexure 1, issued by Odisha Adarsh Vidyalaya Sangathan, applied for the post of physical education teacher. My lord, although he has secured more than the cut-off marks, he was not shortlisted for interview. At that juncture,
Post is
post is physical education teacher,
PE teacher.
a PET, physical education teacher.
Ah.
My lord,
How many posts were advertised?
my lord, the number of posts, 89.
89 posts.
89 posts.
And how many reserved, how many unreserved?
My lord, there is yes. Your Lordship may kindly come to page 15. 15. That category is given. The petitioner belongs to SCBC women category.
CBC?
Women category.
Horizontal.
Yes, horizontal reservation. Well, at the cut-off mark that was fixed for shortlisting or for calling for interview, that is provided under. Yes, you will also may kindly come to Annexure 7 at page 119. My lord, got it?
Yes.
Last but one serial, PT, SCBC women category, the cut-off date, cut-off mark is 33.475. My lord, here the petitioner has secured, my lord, the process is prescribed under, prescribed at page 33.
How much she has secured?
My lord, he has secured total 72.5 marks at page 46, Annexure 6.
Annexure 6, sir.
Annexure 6. My lord, the process for selection, process for shortlisting is, if one has secured, my lord, at least 13 marks in part 1 examination, your lordship may kindly come to page 33, your lordships will be clear. Clause 34.4.
34.4.
Physical education teacher. I am concerned with physical education teacher.
Online test.
The online test will comprise of part 1, part 2 and part 3. All the questions will be multiple choice questions. This test will be 200 minutes duration. Each question will carry 1 mark. There will be negative marking of 0.25 for each wrong answer. Part 1 of the question paper will consist of 40 multiple choice questions in the subject English, that is 20 marks, and ODI 20, carrying 1 mark each. Then part 2. Part 2 of the test will comprise of
Current affairs and reasoning.
Part 3 of the test will comprise of 100 subject related multiple choice questions. Then this is important. Part 2 and part 3 of the test of the candidate will be evaluated only if he or she qualifies in part 1, securing 5 marks each in English and ODI subjects and 13 marks in aggregate. There will be an interview of 40 marks. My lord, here the dispute arose. My lord, so far as part 1 is concerned, one has to secure 30 marks in aggregate, minimum 5 marks in English and 5 marks in ODI. The aggregate mark will be 13.
It is under 3 marks plus.
Yes, 3 marks plus. Your lordship is correct. My lord, now your lordship may kindly see, I have given the answer sheet at Annexure 6. That is relating to part 1.
Annexure 6.
English and ODI I have given. Your lordship may kindly see. So far as question number 1 is concerned, minus 0.25. This is minus marking. He has not answered that question correctly. Then 2, he has secured 1 mark. My lord, got it?
No.
2. The last column. Marks 1. In the box. 1.
You are right.
Then
you have lost 1 wrong answer also you have given.
Yes.
So 0.2
yes.
minus.
Yes. Then you will also may kindly turn to next page, page 47. Question number 3. Here he has secured mark 1. 1 mark.
Earlier one is question number 2.
2. This
One
is
mark. Question number 3, 1 mark.
1 mark. Question number 4, 0.
4, 0. Section 5, 1 mark.
1 mark. Then 6
6,
minus 0.25. My lord. Then 8, 1.
Yes.
Then 9 minus marking 0.25.
Yes.
Then 10, I have secured 1 mark. Then 11, I have secured 0.
12 also 0.
12 also
13,
0.
1.
13, 1. 13, 1. Then 14, 0. 15 is also 0. Then 16
Minus 2.
minus 16, 17, yes, 18 minus 0.25. Then 19, 0.
19, 0, 20.
21.
Stop. English.
Yes.
How much it will be now?
The English. I have calculated.
Total count 7.
But
7 correct answers.
But 7 correct answers. 7
Minus 6, 1.50.
minus 1.50. It comes to 5.50.
How many 0.25?
My lord,
How many 0.25?
0.256. 6 though.
6 or 6.25.
6.
That will be 1.5.
1.5.
1.5.
It comes to
Total is how many?
5.5. 50.
5.50.
Total mark in English.
5.50.
Requirement is 5.
But it should be 13.
Yes, aggregate is 30.
Then Oriya it should be 8,
Yes.
7.5.
Yes. Then Odia. Your Lordship may kindly come. Then Odia starts from 21. Language proficiency test Odia. Here 1. 20. Question number 21, 1.
Page?
Well, same page, page 53. Towards last, towards bottom. Question number 21. She got 1 mark. Then question number 22. Minus 0.25 minus 1.
Minus 22, 23,
23, 24, 25. Then 26, she got 1. Then 27 is also
minus.
Then 28
8 is 1.
1. 29 is 1.
Yes.
30 is minus. 31 is minus. 32 is 1. Then 33 is 0.
4 is 1.
34 is 1.
5 is 1.
35 is 1. 36
0.
is 0.
7, 1.
37 1.
8, 1.
38 1.
9 is minus 25.
Minus 25. Then 40 is 1.
1.
Total. Here it is closed.
No, there is one more, minus 25. Next is?
No, next is not. That is current affairs.
Current affairs.
Today ends there.
You are right.
So here.
How much it will be?
10.
Total. Correct answer 10.
Minus 2.
Minus 2.
Correct answer 10.
10.
Now totally how many answers there we have looked into now?
That is 20 questions. Starting from question number 21 to 40.
21 to 40. Odia. So that comes to 13.5.
15.5.
15.5.
Yes. So therefore,
you should have been selected
for my lord interview. When my lord I was not allowed to sit in the interview, I approached this honorable court and this honorable court passed an interim order. Your lordship may kindly see that interim order. Passed on 16/8/2024.
Go to interim order. Order number?
Order number 3 dated 16/8/2024.
My lord, may kindly come to order number 4.
The interim.
In the interim, petitioner shall be allowed to take part in the selection process, but his results shall not be published without leave of this court. Thereafter,
He was not permitted.
no, thereafter he was permitted. She was permitted, and thereafter result was published on 9/10/2014, 9/10/2024. So far as other candidates are concerned, I filed IA number 16689 of 2024 in this honorable court for publication of result, and this honorable court passed an order on 13/1/2025, order number 5.
Order number 5.
Yes.
7.
Paragraph 3. Considering the nature of interim order passed by this court, learned additional government advocate is directed to provide the result of the petitioner.
Where is that?
Order dated 13/1/2025, 13 January 2025.
To provide the result of the petitioner.
My lords. My lords, we have filed. Did we hard, my lords?
Comply with the order first.
Okay, my lords. That we'll do that.
7 months or 6 months, more than 6 months are over now. This order is not complied with. And government, the conduct of the government is an affront to the judicial process. It wants to fight with the court.
No, my lords, I'll get.
Then why are they not complying with the order? You pass some resolution, we will not comply with any of your orders, we will go home.
No, my lords. We'll get.
When are you going to do that? I'll record your submission now. Or I will ask the secretary.
My lords may grant 7 days time. We'll get.
6 months are over, and what will happen within 7 days? Again, you will say that we'll argue the matter.
No, my lords, we'll get it.
A coordinate bench-wide order dated 13/1/2025 had said as under. First off, more than 6 months have lapsed, and the respondents have not cared to comply with the said order. First off, such cases of non-compliance are not sporadic. First off, day in and day out, we have been seeing non-compliance. Even in matter where challenge to such orders at the higher level has failed. First off, this is a sorry state of affairs and cannot be tolerated any longer. First off, next paragraph. However, as requested, call this matter on Tuesday for reporting compliance of the order dated 13/1/2025, spelling which the concerned officials may be levied with fine in very hefty sizes, payable personally from the pocket. Okay.
All the connected matters are same.
Same order.
Same orders.
There also a same order.
Yes.
Both the matters. Make both the matters.
There are 3 matters.
But similar one. One order.
Item 60.
Brother, we have spent so much time. I was under the impression that I am hearing the matter. It should not happen.
My lord.
Court will not tolerate government not complying its orders. If court tells jump from the 3rd floor, you should get the matter stay or you have to jump. There is no other alternative. Yes.
Item 60.
60, the sole question for consideration is that whether the 18 months diploma in elementary education is equivalent to 2 years diploma in elementary education or not. In the meantime, the Honorable Supreme Court may kindly see.
I have not understood your first sentence.
The 18 months DLED course, diploma in elementary education course.
Diploma
in elementary education.
In elementary education course.
No.
Of how many months?
That is normally 2 years, but the NCT for the session 2017 to 19 for the in-service teachers reduced it to 18 months. Only
Other
for
cities 2 years.
2 years. Only for the session 2017 to 19 for in-service teachers.
18 months. 1.5 years.
Yes. Your Lordship, may kindly see page 24 for a moment. That is Annexure 2.
Are you ready in the matter? We'll ask him first. Is he ready in the matter?
My lords, your lordship call any other day.
Only one thing I clarify, the matter has already been settled by the Honorable Supreme Court. By way of amendment, I have already incorporated the documents at page. Your Lordship, may kindly see for a moment.
But learned friend, because he will have many matters, not one or two matters.
The batch of matters also kind of important. The batch of matters where the question was that whether that 18 months is equivalent to the
2 years.
2 years course. And in fact, you also got passed an interim order protecting that one post is also kept reserved. And in the meantime, the review application was filed before the Supreme Court. And the Supreme Court has said that this 18 months one-time measure. This is that is the order has been annexed. My lordship can only take this instruction, page 98. Page 98, let me look to that. That is sort out the everything.
Brother, just look into it. Government advocate many matters. They have difficulty. Because I was
in fact, Lordship passed an order. If you Lordship look to the order, they had, in fact, time was granted to them to see that if this will be covered or not.
Just look into this. My lord. We will call this matter on Wednesday.
Yes.
Wednesday.
And
all other matters.
Identical matters are that may be listed along.
All along with
each.
Take them. At the request of learned government, AG. You should strongly advise your clients.
My lord.
Or tell them that next time they have to stand before me. Really, I will be very harsh if the orders of the court are not complied with. What for we make the orders?
My
not
lord,
putting in photograph.
My lord, so we are also concerned about implementation.
Implementation is a must. You should respect our orders. We should respect your orders. Mutual respect. We are the coordinate organs of the state.
Item 61.
May I please, Your Lordship? In the earlier matter, interim order to continue.
Interim order to continue.
The petitioner, while working as an assistant teacher under District Education Officer Khurda.
Ask your friend whether he is ready.
Only short question. Whether short
Next week, your lordship.
Disability problem, I am not.
You have discussion with him so that you can tell which space to be ready to. It will help it. Because government advocates will have bunch of matters, not one matter.
So since disability person, lots of.
For week of the next. Some date you can use. At the request of learned AGA. Mr. AGA, in which matter you are ready, we will take up that matter.
No, my lord.
No, there is difficulty. We understand their difficulty because sometimes ministers will not cooperate. They will not give file. They will not allow him to file objections. All these things happen.
That is the problem in the advocacy law.
There is that problem is there.
Problem. They cannot solve.
They will have this support. They have many matters.
My lord, so we get file at 11 p.m. Lords.
Well, I understand your difficulty.
Item 62.
Yeah, we will 62.
I'm in VC Millard.
Yes.
I'm in VC Millard. Yes, where group D employee Millard have been denied promotion.
Yes, sir.
Despite my lord, the rule governing the field and my lord, the order of this Hon'Ble Court passed in 2022. And when I have filed an IA, because the vacancies which are left out now, when they are going to be filled up because of that Supreme Court direction to consider cases of rehabilitation assistant, they wanted to fill up all the vacancies, madam. That's when I have filed IA, and based on that manner, only IA was filed. They have filed a counter, and in the counter manner, they have admitted.
They have admitted what?
They have admitted that rule was not followed, and the direction of this Honorable Court was not followed. That was a specific case, and there is no denial.
Mr. Standing Counsel, are you ready in the matter?
Here I am appealing for the private opposite parties 4 to 9, my lord. The state has filed the counter in this case on 16/7/2025.
But learned counsel is saying they have admitted the illegality.
Since I am the beneficiary of the government, the PC, I must be supplied with a copy of that counter so that I can
share a copy, Mr. Counsel. Share a copy of it. You can ask him. They themselves will give you two. Government lawyers, why they will not give? They will give.
Only one prayer, small prayer, my lord, that I have filed, my lord, at flag A. Let them not fill up further, my lord, the vacancies which are available. At least we can be given promotion.
I'll file objection. Instruction is there. I'll file objection.
When the IA was filed?
IA was filed, my lord, on 30th of June, my lord.
30th of June.
Yes, my lord.
1 month is over.
The instruction is there, my lord.
Saying what?
Instruction is there that they have stated
But they have admitted the illegality in the recruitment process. That's what learned advocate is saying. Your friend is saying.
That was a specific case, my lord. On the face of the rule, they could not have given promotion. And by a committee constituted, my lord, not by the collector.
Don't fill up those remaining posts so that whatever is remaining, something can be done.
Well,
an application is moved seeking an order to restrain the respondents from filling the remainder of the vacancies in the posts in question. First off, learned counsel for the petitioner vehemently submits that in the counter filed by the respondents, official respondents, there is a sort of admission as to there being illegality in the process of recruitment. First up. The learned DAC standing counsel, although opposed the application, no case of defense is made out by Mafesi. First up. Next paragraph. In the above circumstances, to ensure that the writ petition does not become infructuous, application is favored, and the answering respondents are directed not to fill up
20% vacancy, to keep 20% vacancy because that is for us,
to keep 10% of the 20% of the vacancies in question unfilled till next date of hearing.
Item 6. But the matter is fixed to my lord. The matter is fixed to my lord.
Matter, we shall post this matter on 21st week of September.
All right, my lord.
First week of September. That is the date of hearing.
Urgent copy of your
item. Why government advocate here, na? No, sir.
Item 63, my lord. Matter, I have not filed the counter appeal, my lord. Whose time may be given to file the counter appeal? This matter, my lord. Notice on the
for you.
My lord, I am for the university, my lord.
University? Same university where 5,000.
Yes, my lord, but this is matter, my lord. Interim order is there and matter has come for the first time, my lord.
Let it come for the first time. What prevented you from filing the statement of objection?
My lord, read of
this in fact, my lords, in this case, I shouldn't have said my lords, but it is for my lords' consideration. Similarly situated persons. So far, university is concerned, there is a direction that frame a scheme and regularize them.
No, we are asking why the university is not filing the statement, whether it is following the state government.
No, it's not that. It has not happened in that way, my lords, not happened in that way. In that case, there is the writ petitions have been disposed of with a direction that frame a scheme and regularize. which is the subject matter of dispute in a writ appeal, set of writ appeal, including one similar decision person means that is in the department, biotechnology department. That was before minors. While minors were sitting in division, minors are fixed up for final hearing that if the writ appeal, the university loses minors, everybody will be covered under that scheme.
So you don't want to file the statement of objections at all?
Statement of objection, all these minors similarly situated. With due humility, they are all appointed by the heads of the department.
May I be permitted to submit, Your Lordship? I'm appearing for the petitioner. Your Lordship, in this case, we are praying for regularization in a backdrop of 26 years of service. Your Lordship, we are not similarly situated, for we have an appointment order and we were appointed on contractual basis, and we have been working since 1999 and we have an appointment order to that effect also. Your Lordship, in similarly situated cases that my learned senior is referring to, they are daily wage workers and they do not have valid appointment orders. Thereby, the university is claiming that they have been irregularly appointed. In the present case, Your Lordship, under Annexure 1, my first appointment order is there, and under Annexure, Your Lordship, 4, my second appointment order is there.
After selection?
Yes, Your Lordship. After a walk-in interview, Your Lordship.
Which one?
Page 15.
Page 15, Annexure 1 is the advertisement for walk-in interview, and Annexure 16, Annexure 1 series is my appointment letter. I was engaged on part-time basis in a scheme, Your Lordship. In 2003, the PG Department of Biotechnology was brought under the aegis of Utkal University permanently. Pursuant to such, I was appointed on contractual basis. That appointment letter is, Your Lordship, at Annexure 4, page 21, 28 to 2007.
21?
Yes, page 21, Annexure 4. That is my contractual appointment. Your Lordship, the PG Council has resolved to... Your Lordship?
It was in 2007.
Yes, Your Lordship. I have been appointed since 1999 on part-time basis. That was in a scheme under Utkal University. I was reappointed. I was continuing in service, and in 2007, I was reappointed on contractual basis in the PG Department of Biotechnology. Your Lordship, the PG department has resolved to absorb me in the officer cum computer assistant post. The HOD, that is the OP number 6, has multifarious times recommended my case for regularization, but to no avail.
Now may I add, Mars? Kind of a class to Annexure 1.
So beautifully she has argued the matter.
Nice. I do appreciate it, but I like my...
Instead of appreciation, you agree with that?
No, Mars. Only I will point out one thing. I think my lords will appreciate it. Then I will say that we have to wait for the appeal. Kind of class to Annexure 1, page 15.
1?
Annexure 1, page 15.
52.
15, 5.
Walk-in interview.
Walk-in interview. Made by minutes? Made by the coordinator.
Yes.
By a department. Coordinator has no authority to appoint.
But did you take action against him?
No, it's not that. He is paying this. He is not paid from the government, the university account. He is paid.
Who is he belongs to which department of your university?
Coordinator, so far as the coordinator is concerned, is Department of Zoology. What happened?
He is your employee.
My employee, Manners.
I don't have taken.
That is not the thing, Manners. May I submit one thing?
Supreme Court has said this is the thing.
That option is there. I'm not on that. My question is that these people, they are engaging employees and paying from their own pocket, own sources, Manners, collecting from the students. What is that, Manners? Generally, out that some also in department, they have one department called self-financing courses. Out of that, these amounts are paid. University doesn't pay single pie for that. Neither university selected them, and all the departments, but they have done. But who have that what is that called self-financing course? They are doing it, paying it from their managed sources.
He was appointed in August 1999.
Well, that is what was in the department, Manus. In the department, not against any vacancy, no vacancy.
How can a person continue for so many years if there is no perennial requirement?
So, part-time, Manus.
Part-time.
May I be permitted to submit?
If my lord system insists, kindly give me 3 days time, I'll bring all the facts, and my lord should decide that.
Then again, wasting the time. Then what for we heard you?
No, that exactly, that is what I say, Manus. All these will wait. Manus, all these will wait, Manus. Ultimately, Manus, the decision in the writ appeal.
There is no stay for this.
Stay, Manus.
Your Lordship, there's an interim order to let me continue in my post, Your Lordship.
High Court, I'm asking you, if you say, I will be here for less than 1 year. If all of you cooperate, I can do this.
Yes, we're sitting here.
Arguing, adjourning.
We are sitting here, my lords.
People are seeing from the online.
Yes. No, we are, my lords.
They will think that
right, my lords, we are sitting
in the court. Both the lawyers and judges.
My lords, we are sitting here, my lords, watching my lords' minds. We understood my lords' mind, my lords.
Yeah.
But bit time we given so that we will accommodate.
You should have said that's the initial point only. Before arguing, I am not ready.
That is exactly.
That
is exactly.
We are not ready. Fix a date. We will come with.
That exactly, my lords. Standing my lords also some time is required.
Objection is also not filed.
Yes.
University has not filed it.
Counter measures, has come. Counter measures, it can be filed within a 2 months.
Objection.
Fact remains, my lords, in this case, my lords, my humble contention will be, all will be covered.
Levy the cost now, because we have levied already in matter.
That my lords have done it. But here in this case, the case is different, that but whole total matter is pending before the...
You were issued notice. You should have filed the objections, whether matter comes before the court or not. Rules are rules. For everybody.
Yes.
For everybody.
Yes.
Whether this university is teaching law also.
Well, obviously, my lords. We were the students
to pay more.
We were the students, my lords. So there is no dispute. I think my lords will be gracious enough to give me some time.
University has not when the notice was issued. Only the university will know. Otherwise, it will not know only.
Notice
was ordered by a coordinate bench of this court in the second half of 2024. First time. The superintendent of the court sent the intimation notice of admission to respondent numbers 3 to 6. Who are you? Which respondent you are?
Well, so we are for the university is not a party, but 2, 3, 4 minutes.
3 to 6 is already sent to
3, 4, and 5
to the respondents, answering respondents. Wide note dated 30/10/2020, dated 5/11/2024. First time. Thereafter, a coordinate bench's order dated 8/10/2024 was communicated to the respondents on 30/10/2024. Now we are in July, end of July 2025. Until date, no objections are filed by the answering respondents. First off, this is not a happy thing to happen. Next paragraph. You want to file or you don't want to file?
We will file, my lords.
The answering respondents to file. Which respondents you are representing?
So 2, 3, 4, and 4.
2, 3, 4, and
2, 3, 4.
2, 3, 4.
Sorry, my lord. 3, 4, and 5.
3, 4, and 5. The OP numbers 3, 4, and 5 are given a period of 2 weeks for filing a statement of objections, subject to paying ₹2,000 each to the petitioner.
The petitioner, my lords.
How many petitioners?
One petitioner, Your Lordship.
You should have made more petitioners. Yes, next date. Each to
small submission.
Yes. Next. Otherwise, nobody will wake up.
It's not that much.
They're not sensitive. This is not UK. This is India. If this will sleep, you can't do anything. Otherwise, nobody will do. This will follow for the state government also next week. From next week onwards, I
from next week, I
want to become unpopular here. Yes,
not that
I have not taken oath to become popular. I will do my justice orders according to law.
Let that manage, I pray manage, let that be from next week onward.
No.
By this week, we will be filing.
Today is a good day.
Well,
Withdrawal.
64.
Yes.
Your Lordship, interim order is operating in this case. Grateful.
24.
Well, here is a case.
Yes.
The Lordship had issued notice on way back on 8/10/2024. But if I will allow to argue on the same interim order itself, their answer. If they want time, then I will not consume your Lordship's time.
I have to file countermand.
From next week, everything will happen as has happened to the university.
Can I justify the interim order that itself is wrong? One increment.
Much time. Because they will have a pile of matters. See this August, you change it to this side, na?
Yes.
Other one can be made this way. Okay. 21/8 at the request of learned standing council, final. Next time, cost may be imposed. Cost will be imposed. Okay.
Item 65.
55, my lord, here also similar situation. 2nd of December 2024, notice was issued. And filing of counter was given to be 20th of January 2025. We are in July. Here the
objection is not filed.
No. Will counter.
Same order. Next time we will impose costs. 25,000 rupees cost.
This is 21st of
21st.
21st.
66.
Yes, 66.
Previously, I have filed writ application of annex for 14 page 75. I have directed and quoted the pair 75. By virtue of the OP number 1 direction, the OP number 3 DO, he has submitted the bill. When the bill has not sanctioned, I have approved. My lord, this honorable court in the coordinated page, I quoted the pair and directed to consider and sanction the bills. What here
Bills for what?
Mother?
What bills they are?
Bill for area salary.
Huh?
Area salary.
Arrears of salary.
Yes. Though they have paid to others, but not paid to petitioner, is approved. And the OP number 2 in page 78, para 6, rejected on the ground the retrospective promotion to petitioner would unsettle the settled position. He is given to others by the same principle and unsettled the settled person. But in my case, though I have paid for area salary, he is observed that the retrospective promotion. Therefore, on the last date, my lord, this honorable court on 17/6/25 directed to take instruction when the court has directed to consider for area bills, how you have observed that the retrospective promotion. Let's see the order to 17.
Instruction has not come.
Seek instruction and file objection. Because the similar matters others you have given and you have singled out him.
4 weeks time.
4 weeks. At the request of learned ASC.
67.
My lord, 67, I'm beginning to appear for the petitioner, my lord, virtually.
Yes, sir. Matter is taken up with
My lord, I beg to appear for the petitioner virtually, my lord.
Why should you beg?
My lord, I am appearing virtually.
Yes.
My lord, 67. So far the OP number 5 and 6, notice has not made sufficient.
You take steps for them.
No, my lord, I will, but there was a direction for my lord submitting counter. Probably, my lord, that has not reached to us, a copy of the counter. 2nd of April, order your lordship kindly peruses.
So you want copies of the petition?
No, we have got the copy.
My lord, the counter.
Not there, man. 5 and 6. 6 is the independent Odisha Public Service Commission, my lord. They are panel of lawyers.
5 and 6.
5 is the...
5 and 6. We will serve afresh, but the answering respondents are 1 to 4, especially the special secretary.
But to all of the respondents, you have to serve copies.
My lord. Sure, my lord. Sure.
Pleadings to be served on the counsel representing all respondents. It should be done within 2 weeks. 68 petition may be dismissed on that ground. May be rejected on that ground.
Earlier, writ petition was allowed. By judgment, page 62, praying for appointment in the post of Shiksha Sahib.
Brother, we have a DB, one division bench. So you have to give me short adjournment.
Item 69 tomorrow. Item 69 tomorrow may be taken up.
We have already posted the many matters.
69 here, government has to. That will continue.
Interim order is granted, just look into file, continue the interim order till next date of hearing. Call them in the month of September.
69 by virtue of the interim order, our promotion has been stopped. That's why, because this is very urgent, taken up.
Promotions are never
Promotion, because there is
Intervention application.
Bunch of matters are there. Today it is in the list. Other side is for the tribunal. Yet government has to file the counter.
So we will intervene in this case because if you are query for one moment, this order, which is the order has been lost.
Let government say.
Just of the cases.
Item, for judgment, item 2.
We have taken a little longer period to pronounce the judgment because many judgments were cited.
Last week, your lordship has asked this no.
Last week, but so many days we should not have taken. My brother was also
No, we
in
are
other
fortunate.
bench.
We are fortunate that your lordship has discussed the matter so well.
We have referred to most of the relevant judgments, more particularly, even your case we have treated along with these matters only.
Yes.
Because you agreed other day that it need not be treated separately. Okay? We have referred to Umadevi, Kesari, and Jago.
Yeah.
The latest one, 2024. We have Jago. And we have also referred to 2025 matter.
Shripad.
Correct. Great one. And we are constrained to make this order, which will not be that happy to the appellant. The appellant board, in the above circumstances, these appeals being devoid of rates are liable to be and accordingly dismissed, costs having been made reluctantly made easy. The appellant board and official response are directed to implement the impugned orders of the learned single judges and report compliance to Registrar General of this court within an outer limit of 3 months. Default or delay shall be viewed very seriously in the next level of battle if waged by the respondent employees. You have to create force. We have just together, of course, my brother helped me. We scanned section 9 of the Act. Section 9 gives power of appointment to the board itself. Therefore, the argument that board committed illegality in making appointment will be not number one. Such an argument is not available to the board because board itself has committed. Therefore, if allowing him to take benefit of its own fault, that is not agreeable. The second one, direction to create the posts and sanction them. The learned judges have given to the government. Government is not in appeal. You are in appeal.
Yes,
You are less than the government. If government is happy with the direction, how can you make out a grievance against it? That's how we have structured the judgment, which all we have argued very well. We have added our arguments also to this case.
Yes, argued very well.
We argued very well.
That has been highlighted by an esteemed senior.
We argued very well. But every point wise we have treated.
Before it proceed is delivering the judgment, I was also asked this question. How you are acting?
Two matters.
Item 1.
That was item 2. This writ petition we have referred to, that State of Jammu and Kashmir versus District Bar Association Bandipura, and that referred to Renu versus Delhi High Court. That where these appointments have to be made, you have to follow the rule and regulations. And in this case, the family judge was not authorized. I think he's not there. You are appealing for the appellant. Sorry, the petitioner. The family judge is not authorized to make that appointment or advertisement.
That's what Mohanty pointed out. Committee is
there. Committee. So we have referred to your submissions also, that that committee, how it is defined and all this. In view of the discussions made above, the writ petition being devoid of merit is dismissed. Costs made easy.
Judgment is very beautifully come. I have read that.
It's not correct.
But typographical error in a matter to